afternoon, everybody. A very warm welcome to the first SMC-SIMC joint workshop. So you may know that SMC has actually been around for quite long, and Singh will introduce SMC. But before he goes to that, let me just say a little bit about SIMC, the Singapore International Mediation Centre. We were officially launched 5th of November last year to really grow the space for international commercial mediation in Singapore. So our focus is on conducting mediation for cases which involve a cross-border dispute. And so to support that, we have a panel of international mediators that's different from SMC's panel, and we also have an international panel of experts to support the work of the mediation for very technical cases. The final product that I'd just like to share with you about is our ArtMedUp service that SIMC has collaborated with the Singapore International Arbitration Centre for. This is meant to be a package service which combines arbitration and mediation, allowing a party to commence the arbitration process, but segue into mediation at an early stage to see whether the dispute can be resolved amicably. If so, the mediated settlement agreement can then be brought before the arbitral tribunal for them to record that as a consent arbitral award. That is then enforceable as an arbitral award under the New York Convention in more than 150 countries around the world. So this product really is designed to try to support international businesses, and that's really what the SIMC is about. And so I'll now pass the time to Singh to say a bit more about SMC.
Thank you, Eunice. Good afternoon and welcome to today's workshop, seminar, conference, what have you. Mediation for the business community, a powerful tool to resolve disputes. We have an interesting lineup for you this afternoon. Rather than two talking heads as you have now, what we will have is a group of people playing parties, lawyers, and a very, very good mediator to show you what mediation is. And along the way, you'll not only find out what mediation is, but why we think it's the best thing since sliced bread. My name is Singh. I'm from the Singapore Mediation Centre. We've been around slightly longer than SIMC. We were formed in 1997, so that will make us 18 years old this year. Our focus is on providing mediation services for domestic disputes. Focus is on commercial disputes, but we will handle any sort of disputes, even if it's a neighborhood dispute. As long as you're willing to pay our mediation fee, we'll try and help you sort it out. Apart from mediation services, we are also very much involved in training, building capacity, helping people improve their mediation skills, helping companies, helping even mediation training in foreign jurisdictions. We do quite a fair bit of that. Also consulting, helping people set up mediation centers. In short, we want to make the world a better place. So with that, ladies and gentlemen, I think we shall invite our esteemed role players, lawyers and mediator on stage to introduce them one by one.
Yes, we'll just introduce them as they come on. So we have two moderators for this session today. We have Lim Tat and Josephine. So they will be managing today's session.
Then we should invite,
and then we'll invite our role players, starting with Professor
Lawrence Wu.
Professor Wu.
Lawrence has been a mediator for a very, very long time. He's got a wonderful track record in terms of mediating, much in demand. I won't say more, we'll let him prove himself. For the parties, we have
Miss Ng Chai-Ni and Mr. Richard Kao.
Okay, don't let Chinese appearance see she's actually Korean. But she's meant to be Korean today. For the two lawyers, we have Mr. Ramesh Selvaraj
and Mr.
Amolat Singh. Please give them a big round of applause.
Right, thank you very much. Lim Tat, come stand in front of us. Before we start, let me just reintroduce. He's the one who's called Lim Tat. I'm Josephine. Okay? So my name is Josephine. I'm regional counsel at Texas Instruments. So, but like Superman, I also have that's my day job, but I also have a night job, and that is to be a mediator and a mediation trainer. And here is Lim Tat. With that, we'll introduce
Hi everyone, I'm actually in private practice. I've been in practice for about 25 years, and one of the areas of work that I'm very passionate about is resolving disputes in ways that are collaborative. So I'm hugely into mediation and very happy to be here to share this session with everyone, and hopefully after today we can, take away something from this session. So
over to me. All right.
Yeah.
Okay. So let me just set the stage for us right now. We've heard from the wonderful Eunice and also quite wonderful Sing On. But I want you to be under no illusions whatsoever, because the people in charge today would be me and that.
Yeah.
Okay? So you're in good hands. So what we're going to do is we're going to introduce to you, and at certain points we will stop and explain to you and debrief a little bit about the process itself, and give you an opportunity to ask any questions at all. So there will be certain junctures where you get a chance to ask. If you have a burning question and you cannot wait, if you look down, you'll see they should have provided you with a piece of paper, a pencil. Write down your burning questions. We will just work through them when there's a chance for you to speak later on.
I thought maybe we can keep this extremely flexible,
Yes.
just like mediation is an extremely flexible process. And I reckon that, standing there just now, that some of you might not actually be able to see the demonstration. So what I'm going to ask you to do is, feel free to stand up, walk around. If you'd like to bring your chair somewhere closer, that's fine as well. And if at any point in the course of the role play later on, you have any questions that you want to put a comment across, just raise your hands, and then we'll stop the role play and then invite you to say your comments, and we can have a little chat or discussion. So we want to keep it that way.
Yeah, so we keep it very, very informal. And so I know you already know who the cast of players are. These are actually very esteemed professionals in their day job. They may have aspirations to be in Mediator or Hollywood or Bollywood. I don't know. Otherwise, you will be the judge of how good they are as actors after today. To start with, I thought that we could do a quick straw poll.
Yeah.
How many of you here have actually been in a mediation? Can you just raise your hands? Okay, that's how many? Is that 1/3? 1/3? That's not too bad, not too bad. How many of you have actually mediated? Okay, that's about 1/5. 1/5. It's very good. Very, very good. Okay. How many of you have actually seen the mediation in progress? Okay. It's strange that there are fewer who have seen the mediation than who have participated in one. Okay, but that's good. That's all right. That's all right. Well, the good news is that after today, all of you will have seen one. Okay. All right. So without further ado, I'm going to hand the time over to our mediator, just so you can't see. If you can't look, there's a giant pillar here. Can you guys see him? Can you guys see the action over here? All right. So. Oh, yes, that's right. Go. It should be in your slides.
Have you all got, within the materials you have, the facts itself? No, right? So what you do with it? Okay, great. So if you had, if those of you who have had a chance to read the facts, this is what the role play is going to be about. If you haven't, just spend a bit of time now to go through, because having an understanding of the background will help you understand the dynamics of the parties' relationship, how they're communicating to each other, and what the mediator tries to achieve for the stages of mediation. Okay.
Sorry, hi. We don't have facts. Quite a few of us don't have.
If you have a look at this screen over here, all right? For those of you who don't have the facts, take a look at the screens on your left and on your right. Okay?
Probably we'll be able to, you can get it from our discussion.
Yes, our mediator probably doesn't have all the facts either. And that actually reflects reality sometimes. Huh? Okay.
So maybe as you read the facts on the screen, we can get the mediation started. Yeah, sure. And then as we roll on, and you have any questions, then just raise your hands. Okay, so with that, perhaps we set the stage here and explain what just happened, and maybe we'll pass that mic over to Amolat.
Okay.
Yeah, okay.
Fantastic.
Well, good afternoon, everyone. Good to see you. Some familiar faces. I see lawyers. Very pleased to see you. My name is Lawrence Wu. I am here to conduct this mediation. I understand that there is some tension between the parties arising from some business arrangement they are involved in. So, I've not been in mediation for very long. In fact, I've not been mediating for the last 2 years. So, please help me if I really seek your cooperation. Please go on, take the call. It's okay. We'll wait for you.
He was just checking whether he has the authority to be here with his boss. They found him missing in the office.
I'm in a bit of a rush, so if you can wrap this up quite quickly. We'll try, but things we have to move as we go along. I'm sure we'll find that we'll move faster than but I really have not been mediating for the last few years, so just be patient with me if you could just tell the boss that things will move. Okay. Yeah. Okay. First, let me congratulate you for coming to mediation, because it takes a lot of confidence on the part of the lawyers actually to come to mediation, because they're actually giving up a lot of themselves.
I'm losing quite a lot of money coming here actually, but I believe in mediation, that's why I'm here.
Yes.
My client is also sold on mediation.
Oh, that's great.
He has read this book, Cut Through the Clutter for Swift, Cost-Effective Results, cover to cover.
Let me just get the party's name right? Yeah? You are Mr. Amolat.
My name is Amolat.
I'm Richard, from Sales Director of Singh Limited.
Okay. So you are very high up in the hierarchy?
Yeah.
Of course. Very good. Thank you.
Good afternoon, sir.
Yes.
Ramesh and Selvaraj.
Mr. Selvaraj. Yes. Can I call you Ramesh?
Yes, please.
Okay.
I'm Chai.
Chai, as in chai tea?
That's not how we cook it.
I'm sorry, I'm not sure how to address
Like
you.
someone is
Miss
I'm
Ngee?
Chai.
Chai.
Miss
Or
Chai.
as in vegetable.
Yes. Thank you very much. I'm the CEO of KFC,
Okay.
a very distinguished brand of cosmetic vehicle.
I use in skin.
Well, sorry, don't cater for women, not so much.
There are men products, a face shop. They're all good Korean products. I'm pleased that you are all in the same business in which my daughters are very interested in. So, well, let's see what's the problem here. But before we go there, let me just explain that today I'm sitting here as a mediator. As a mediator, I will not make decisions for you. I'm not a judge or arbitrator. My role is to help you bridge gaps and see whether we can diffuse some tension and hopefully come together and achieve some resolution of the matter that seems to be on the table. Of course, I need your cooperation, and I'm very pleased that lawyers are here. They are the most helpful people we can find in any dispute. Yeah? And they are your best legal advisors. So I'm not here to give you legal advice, to pass judgment on this matter. Okay? So I want to explain my role here. Yeah? And also to allay any fears that whatever we say here can be used subsequently for a chance that we don't resolve this matter. Again, encouraging you about 75 to 80% of our cases do get settled. But that's very long ago. Yeah? So I've not been doing it the last 2 years. So I need you to encourage me today.
Can I just clarify?
Yes.
I mean, whatever that we say here would all be confidential?
Yes, we will keep this confidential. None of us, there will be no recording. And the camera there is just a dummy. And all these microphones are just dummies. They're not recording. We're just putting it for show so that we look sophisticated. So don't worry about it. So whatever you say will not be used against you. Any offers that we make or compromises that we make that will not be cannot be used outside this proceeding. So you feel safe and feel free to make suggestions, bring value to this matter as much as you can. And that's why I need your cooperation, especially from the lawyers. Each of you will be given, in terms of process, each of you will be given time to firstly address me openly. And please forgive me again, I'm not familiar with the facts, so it will be good that you explain to me what your intentions, your purpose, your positions, and then you will give me a better understanding. There will be times in which I'll be asking you questions purely because I don't understand, and hopefully you can explain that to me. Again, I seek your understanding and patience in doing so. Okay, we will then break up into what we call caucus session, or basically private sessions, which I will, during those sessions, hear further from you. Maybe there are certain things that you want to share with me, and I may have more questions for you. Sometimes I take longer with one party than the other, but this is no indication of my doubting them or I'm trying to play a game with you. No, some people. Usually it's my fault for not understanding your case or positions.
Can I ask why do you need a private session? I mean, everything should be disclosed here.
Yes, as best.
What if he tells you something that she attacks me in private and
as best we can, we will have as much time in joint session.
Why is he worried that there are reasons to attack him?
I mean, come on, we have been doing this for such a long time. We've been talking about this for so long. There are many things that you say about me, about my company behind my back. Come on.
I didn't say it behind your back. I said it right
in front of me, yeah? Okay, so
my lawyers will deal
there you go.
I can sense, as I said earlier, that there's tension between you two, at least for the moment. Let's see how we can go along and see whether we can, at some stage, address some of those feelings that you may have. And that's why we need to have some caucus sessions, private sessions, to understand what's behind all this. So if you allow me, I prefer to have 1 or 2 private sessions. Is that okay with you? Yeah. And also, I want to, during those sessions, I think in private, I can be more brutal with you, say. Yeah? I can be very frank with you. Not that I'm not frank in open sessions, but I want to be brutal with you in the private sessions. Because when there is a dispute, most of us think we are right. And I think both of you take positions that you're right. But here we're not talking about who's right and who's wrong. I'm more interested in what is in your interest that is more important. Let's see, and then at the end of the day, after the caucus, we'll probably bring you back. And hopefully, we can come to a better understanding. Hopefully, some solutions can be brought forward, and we can discuss them. And if, I should say, when we reach a settlement, we will sign off the document. Until we sign off the document, everything you say is not final. So that hopefully encourage you to come up with solutions and work with me. The flip charts here, we will put up points when we need to, if you think that you are afraid of forgetting having to put it on the board. Is that okay? Any questions on the process?
Let me talk to my lawyer.
Sure. Okay? If you understand the rules of the game, then we will start by asking one of you to maybe address me, and explain the case. I really don't know very much about the case.
I'll be the gentleman here. I'll let the ladies talk.
Okay. Mr. Ramesh, okay.
Yes,
yeah, yes.
Good afternoon, sir.
I assume as the CEO you have no one, you need to not report to anyone else, right? Mr. Larson, to you have full authority.
Yes, I do.
Thank you very much. Yes, Mr. Ramesh.
So, thank you, sir. So just prior to this mediation, we had entered into your officers a set of our mediation briefs, and I trust you would have had an opportunity, perhaps not to read it in any detail, but I trust you would have had an opportunity to at least peruse through those written briefs.
I have a brief that both of you have submitted, and the mediation agreement, signed by both parties about confidentiality, but nothing else.
Sure. Perhaps what I will do is, because my client has requested for me to address you at the opening, perhaps if I could just take you through the salient points of my client's position, and then we can hear from Mr. Singh thereafter. So, as you know, I act for KNC Company. KNC Company is actually a Korean corporated entity, Korean company.
It is in the business of developing and the manufacture of luxury cosmetic products. Organic, I clarify, organic cosmetic products.
Chemical free.
That's right, chemical free. The dispute, if I might say, relates to a JV, a joint venture, which my client had entered into with the Singapore company. The Singapore company in question is Singapore Limited. Mr. Singh acts for Singapore Limited. Singh Limited is a company which is in the business of importation and distribution of beauty products. And they've been doing this in Southeast Asia. We have reason to believe, and when I say we, I mean my client, have reason to believe that Singh Limited is a strong network of wholesalers in the region, Southeast Asia. So the whole purpose of this JV was to set up a new entity which my client could use to market and sell and distribute their products in Southeast Asia. So it was symbiotic relationship. We knew that they had something to offer. We wanted to get into the market in Southeast Asia. So it seemed like the perfect solution to enter into a JV, which is what our client did. Now, the JV has been effective now for 1 year or so. A number of serious concerns have since arisen. And I'll take you through those concerns. And I think these are the concerns that we think needs to be resolved. And that is why we've come here. The first concern that we have is this. Now, you recall, sir, that I mentioned that JV was set up some 1 year ago.
Yes.
Now,
it's been working around for 1 year.
Well, unfortunately, not quite.
No, I don't agree. No, sir.
Mr. Lau, to help me, maybe when they are talking, you just bear with me and bear with them for a while. I think I was picking up on the word effective. It's been effective for a year, so not running well.
Unfortunately, sir, that is not the case. The sales figures that the JV is presently looking at is well below Singh Limited's earlier projections.
So again, I can't take this, I mean, I don't agree with whatever he's saying, right? I mean, what do I do now?
Mr. Lau, I think what we are
Yeah, I'm afraid that you just listen to everything to him, man.
Mr. Lau,
and you see, this is what I have to deal with for the whole year.
Thank you, Mr. Lau. The thing is, at this open session, I really am trying to understand from one side. And in a short while, I'll be asking you or Mr. Singh to address us, to address me, and explain yourself as well.
Sure.
You will not be shortchanged. You won't be shortchanged in time. I'll hear you. Yes, Mr.
Thank you, sir. So we're on the issue of sales figures that JB is currently looking at, and these are figures well below Mr. Singh's client's earlier projections to our clients. We were given a very rosy set of figures, very rosy set of projections, and we say those projections were what induced us to enter into the JV. So from a legal point of view, if I might say, we're looking at misrepresentations that were made. I would even say these were false representations made right at the onset, which then induced us to enter into this JV. And we are now looking at those sales figures, and they're nothing like the projections. We're talking way off the projections. So that is, I think, foremost our concern. It doesn't look like we got what we bargained for. Now, there is yet another issue that I think we want to deal with. This concerns a number of our clients' employees. And these are employees in our clients' research. Very key employees, as I understand, in our clients' research and development department, R&D department. They have intimated to our client that they wish to resign. In fact, a number have already resigned, and we are hearing on the ground from the grapevine that these employees are believed to be joining, lo and behold, Singh Limited, Mr. Singh's client. And we are hearing again that they are going to be joining Singh Limited to work on developing a new brand of luxury cosmetic products meant for teenagers. So this is what my client is hearing. To make matters worse, what we're hearing on the ground is that not only are these employees seeking to join Singh Limited, in fact what we're hearing is that Singh Limited has been actively poaching these employees, reaching out to our clients' employees, inviting them over to join them. We say again, from a legal point of view, that amounts to inducing a breach of the employment contract entered into between our client and the employee. So that we say is of serious concern to us. And what's a lot more egregious here, sir, is that we are also hearing that the manufacturing method for this new product line is going to be based on our client's own very technology. So this is technology that our client has developed. These employees have been the very employees that have developed this technology, having spent time in the R&D department there. They're now going to be going over to Singh Limited, sharing this technology with Mr. Singh's client, with a view to developing an entire new
Maybe you can come help me because we don't have much time in terms of the time we set for today. Normally we have a whole day, but because we have a half day today. So can you tell me what then will you see that will you see in this mediation? Surely your desired position is how do you see this mediation work?
Well, sir, I think what we
want
want
to like to see at the end result.
Sir, I hear you. I think what we want to do is we want to set up the issues on the table. Make that clear for you, sir, so that we all know what issues are there that we.
Based on your brief, I understand that your request for mediation that there's an arbitration going on, or you are commencing and seeking injunction or something like
yes,
that.
Yes, okay. I should say that under the JV agreement that was entered into between the parties, there is a arbitration clause. At this stage, we have not as yet commenced any arbitration. We are quite keen on going down that route, but we are hoping that can be avoided, which is why, in discussion with my client, we decided perhaps it would be worthwhile giving mediation a shot, which is why we're here. So, what I've been doing so thus far, sir, is to sort of outline a number of the key concerns or issues. I've talked about the sales projections falling well behind the initial figures. I talked about the employees, poaching issues, so to speak. And just two other points I'd like to make, sir. And then I think I would have, in a sense, set up all the key issues for consideration. Now, on this new product that I was talking about, which I understand that Singh Limited is going to be marketing, now, fundamentally, our client has a key issue with it because you heard earlier why this JV was set up. This JV was set up to sell our clients organic, luxury cosmetic products in the market, focusing in Southeast Asian region. Now, if Singh Limited was going to be launching a new product line, it would be effectively competing with this very JV in the market. So, fundamentally, we think that goes against the very essence of the JV relationship. It would no doubt, we say, hurt the business of the JV. The JV is, as I said, a new entity on the market. It is a baby in the market. The actions of Singh Limited would be effectively far-reaching. They're not helpful, certainly. Yeah, I mean, clients have serious concern as to whether or not the JV can continue as a going concern. And again, we say from a legal standpoint, a legal point of view, this is also amounts, the actions of Singh Limited amount to a breach of the JV agreement that was entered into between the parties, which is the agreement that contains the arbitration clause. Lastly, sir, I think insofar as this new product line, which Singh Limited is looking to launch, I mean, we're hearing that Singh Limited has the audacity to even want to register a patent for this new technology. New insofar as they are concerned, but this is our technology, our client's technology that our client has developed as well. So that is a serious concern for us. This is effectively theft by the employees and Singh Limited of our technology. We have to date, we should say that our client has not as yet registered any patent. So we've in a sense amassed rights over the years, and with any patent coming to be registered by Singh Limited, our client risks losing its rights so far as use of this technology is concerned. And that is a big issue so far as our client is concerned, because much time, effort, money, and resource has been invested in this technology. So which is I think the point which sir, you made earlier when you referred to our mediation briefs, having mentioned an injunctive regime or injunctions. That's something that we're potentially looking at, because we certainly don't want a scenario where Singh Limited has gone about getting a patent registered. So if we do go down the route of commencing arbitration proceedings, we're certainly going to seek remedy in the nature of an injunction, an urgent injunction, perhaps even on an interim basis, to prevent the registration of any patent pertaining to the technology by Singh Limited. So I think what I've done is basically set out the issues for you, sir. Unless you have any further questions, or unless my client has anything she wishes to add, I don't think there's anything further.
Thank you. Listen, you want to say something?
No, I think to answer what you asked just now, but what I would like at the end of the day is for them to stop quoting my staff, stop stealing my technology, and do something about the joint venture sales, because that's essentially, why I came here today.
Well, thank you very much. I think if I understand you, those 3 points you mentioned earlier are some concern to you. And that is, if I understand correctly, what you're saying is that you believe that the sales figures were not achieved, and that you would like to see it improve. You're also concerned with how the employees are being treated, and whether or not there's an attempt to lure them away. That's your concern. You're also concerned with the patent rights and new products that you hear that you've heard that they are developing. Those are the key areas you understand. Later I'll put this up on the board again so refresh our memory and keep our focus on that. Yes, but let me hear them and let's see what their response is.
No, I will let my client speak because he knows the facts the best.
Yes. So, sir, I don't know about you, but I didn't hear very much of what you said, because I said that this was like a court case. It's all like legal arguments, right? Am I supposed to present legal arguments now? If that's the case, then I'll let my lawyers do so. Otherwise, I'll be happy to tell you my story in my own words.
Let's do so any way you like.
Maybe I can save costs too.
Sure.
Why not?
It's okay. It's okay, but my clock is still running.
So, sir, let me tell you my story. Yes, I'm very happy to hear that you use beauty products. So you understand my industry, my business, right, sir? And as you know, Singh Limited is famous. Singapore, Batam, JB. You'll see the advertisements splash all over. We import organic products for distribution into Southeast Asia. So, we're looking to expand our business, and then along comes my Korean friends. They say that they are in this, doing some funky organic stuff or whatever, and we could just enter into business together. They'll produce their products, I distribute. Perfect, right? symbiosis. But things didn't go as well as it was made out to be by the other party. Sometimes it's good, sometimes it's bad. I think maybe because my staff are all made out of males, and anyway, I'll probably do that later on. So anyway, a couple of months back, for some reason, I don't know why, her staff started resigning and joining my company. Of course, I have no issues with that, right? I've all along wanted to develop this beauty line, beauty products for teenagers, so that you and I, sir, we can look more like the young hipsters. So that was perfect, right? But then again, I presented the proposal to my Korean partner, but she just wasn't keen. So anyway, I thought, okay, I'll just do it on my own. And I don't know why, but I guess their staff must have been kind of tired of their management style or their lack of vision or whatever, and they just resigned and joined the company. So there you go. I'm more than happy to proceed with that, develop the products, and my intent is really to develop the patent or something like that, patent, yeah. So register that so that I have a right to distribute all over the world. So there you have it, and then suddenly I get this notice of, what is it? Arbitration. Saying that I stole their stuff, I misrepresented my numbers, and wanting me to shut down my business, etc. I don't know what they're talking about, right? So anyway, I consulted my lawyer, my expensive lawyer here. He tells me, no coaching, definitely no coaching. So I'm confident that even if we go to arbitration, we'll fight it out. Not an issue. My lawyer will defend me. Misrepresentation, what misrepresentation? I tell them my forecast based on what I know. That's exactly what I tell them. I can't control, right, if the economy is bad, if there's a war in the Middle East or whatever that happens that affects the supply line, or if the K-pop stars are not doing well, then the products they go bad. I can't control that. So there's no misrepresentation. So really, at the end of the day, I'm sick and tired of this. If they want to sue, just go ahead and sue. Okay, I'm more than happy to see them in court. My lawyer is more than happy than me to see them in court, right?
I'm more than happy, but also very ready. But since I'm a firm believer, as I said, sir, in mediation, where I think I've told my clients they will be the decision makers in this process, as opposed to going to court, where somebody called a judge will make the decision. My client is sold on that.
Yeah, Mr. Singh is kind of like a lawyer.
But I must also add, just now my learned friend kept referring to me, Mr. Singh, and this company, Singh Limited. I have nothing to do with the company. It may sound the same. Singh Limited, Mr. Singh, but I'm just a lawyer for them.
So if I understand your case, you would like to see, you are interested in expanding marketing and
that's right.
more
Yeah.
sales.
Yeah.
This is so you have the same intentions on your side. You want to expand your sales.
I'm not as rude as him, I don't interrupt, so may I speak?
Just a moment. I'm trying to understand Mr. Lau. Let's give him a moment.
Because he said he's not interested in the mediation, so why am I going to sit here for? He wants to go to court. We feel very strongly that we have a good case, right?
Mr. I think the fact that he's here is a very positive sign. So let's take it at face value. Okay?
Let's hope so.
Is that okay? Now let me just understand you, Mr. Lau. You similarly like to see increased sales.
That's right.
Because you're saying that it's the economy that's not going well. You, like them, also are into hopefully producing new products, developing new products for sale. So you again also have common interest in certain areas. So actually I see there's a lot of common interest between you and I don't see how going to litigation or arbitration is going to help you. So I'm very happy to continue this session and see whether we can look forward and see whether we can work towards a solution. I hope you are with me. I'm with you this morning. I feel that there are a lot of common areas in which you are on the same page. And see, it will be such a waste if we put it forward. You want to freeze me?
Great. Freeze.
Okay.
I saw it.
So,
Anytime.
so I think we'll pause here for a moment because some of you may be wondering what's happening. And we just want to pause to let you know that even for, if you go to court and just show of hands, how many of you actually have been observed trial taking place in court? Just want to see whether you're familiar. Okay, so you know that if you go to court and observe or participate in an ongoing trial, there is a series of steps. You follow a series of steps, and the lawyers know exactly what to do. It's very much driven by the lawyers and the judge, isn't it, if you go to court. What we are trying to show you here, and maybe invite your comments, is I mentioned in the beginning that mediation is meant to be extremely flexible. And in the sense that it's flexible, of course it depends on the stakeholders here, the parties here. So all of you, if this was a dispute that involved your company or yourself as a professional, a service provider, you'll be either sitting in this seat or that. And it's useful to ask you, if you were sitting in that particular seat, how would you have done this if you were sitting here? Would you have done it exactly how you observed the parties doing it, or would you have done it a slightly different way? Let me just show, first of all, the mediation stages. And I think for many of you here, because you see familiar faces, I think you'll be extremely familiar with this diamond-shaped model, isn't it? Yeah? And I'm just going to quickly ask if anybody has any questions, because what we're showing you up here is a process of mediation in general, from the top down. And what you have observed in the last maybe couple of 20 odd minutes is the introduction, where the mediator sits here and gets everyone comfortable. The mediator does his opening statement, where he tries to explain, his own, how he wants to run the process. And then looking at the parties, asks whether they have any questions. And then he goes into inviting each party to open and state their case. I think all of you are with us, right, on that demonstration. What probably is useful is to ask yourself, could it have been done in a different way? And I'll give you some thoughts. For instance, in some forums, the mediation doesn't have to be in this sort of setting. And in some disputes, it may be useful for the mediator to adopt a more informal setting. So for example, in that sort of setting, Lawrence may want to take off his jacket, take off his tie, and that's about it.
That's all we want to see for the moment. Okay.
Or he might want to...
No. That was optional, but okay.
Optional.
Can the parties please keep the clothes on,
You might at the outset
Don't get excited.
Bring drinks or invite parties to have a drink. Because in the local flavor, having drinks or having maybe a little bite together often lightens the mood. Yeah? And then as the mediation starts, what does he say? Does he invite parties to call him by his first name? And then when parties call him sir, does he move away and say, don't call me sir, call me Lawrence? Because if you allow parties to call you sir, sometimes it becomes a quasi-tribunal hearing, either arbitration or because the parties are in that frame of mind, they call you sir and then they submit as though it's a quasi-court setting. So I invite you to see how it unfolds and ask yourself and ask the panel here why they did it a certain way or whether they would have done it a different way. And then let's segue from the mediator into the lawyers, for example. The lawyers were, at least this side, they were demonstrating, Ramesh was demonstrating a formal approach, which you'll probably see in many commercial mediations. Because the lawyers take on board, they speak, they drive it because they want to protect their client as they are paid to do. Query whether that's the best approach. Because then it segues into an area where it's pretty much similar to submission support. One of the things I did in one mediation is actually to speak directly to the protagonist on the other side. And I said, Miss So-and-so, we have our position, but we're not here to talk about that. I want to tell you why my client feels upset about the unfairness of this whole thing. And my client feels that she should not have been taken to task in this case because she was not responsible. So I spoke directly to the party, looking at the party directly. Does that help or does it not help? And then for the parties themselves, if you are the client, the company rep, or the counsel, the general counsel or in-house counsel, do you want to surrender your piece, at least even in the opening stage, to your counsel? Is that helpful? Or do you want to seize control of that moment to say what you want to say directly to your other side? Is that more helpful? And those are the series of things we invite you to consider. Because of course in a court setting, everything is structured. You can't just set up and say, I want to say something if you don't mind. I'd like to talk about fairness. I'd like to talk about certain things which are not connected to the dispute, but nonetheless, it's good for me to say that. You can't. But in mediation, we say it's flexible because you can say to the mediator, there are things I want to say, and these are not necessarily connected to the case at hand, but they're important. And I want to speak directly to you, the other side, and tell you my thoughts, why we are here. That is invaluable because you don't get that in court. So I pause here for a moment and ask Joe to...
So, now that you have the mediation stages diamond in front of you, and you've seen some of what's gone on, I know for those of you who may not have seen or experienced mediation before, it may look like just a whole bunch of people talking. Okay? But now that you have the diamond, can somebody make a guess as to what stage we were at? Is it stage? What stage do you think the process was at? Just a mild guess. But just know that if you get it right, you won't get a prize. Sorry, I have to disclose. Which stage do you think is it? Is it at introduction? Sorry, what was that? This is a nice gentleman. What's your name?
Tony.
Tony.
Hi, yeah. My name is Tony. Just a couple of observations. I'm just asking a question. Summary of Party B statement, I think, is where we are right now. Yeah. And maybe I have a question actually, just since this is all time for some observation.
Yes.
What in some cases I also noticed that maybe perhaps there's a different scenario where the party might not come with a lawyer. In this case, we have both parties represented with a counsel. But what if it's one side have no counsel, or perhaps both sides? So, what difference does that make? That's question number one. The second observation is I realized in the in Lawrence's summary of parties, my own experience that I probably do a little bit more summary, but I think you did a nice way of making it very simplified. You just go straight to the point of taking the more essential point of the concerns. But I was thinking whether that could be sufficient in terms of summary, where there was a lot of points being brought up, for example, by K and C. So perhaps something that I might do it differently in terms of the summary.
Thank you, Tony. So he's got two questions. First of all, where did you say it was? The stage was?
Summary of Party B statement.
Summary of Party B statement. Before we get to the questions, anybody has a different answer? No? Agree? Agree? Okay, here. What was your name?
Carol, hi. Well, I think we just finished anyway the summary, so you just gone on to the agenda. So but we're in between, aren't we? So we just finished the summary, we're now moving on to the agenda, is that right?
Are we right? We will ask Lawrence later. So I'm just going to collect some questions later so that we can discuss as a whole. So Tony's question was the summary sufficient, and also what would happen if one party would come with a lawyer and the other party doesn't come with a lawyer? So those are the two questions. Anyone else has any other question? Yes? No? On this side of the room. Oh, yes, what was your name now?
My name is...
Here you go.
It's Vijaya. My question is...
Virginia.
Vijaya.
Vijaya.
Yes,
Okay.
Vijaya. It's not a question, it's an observation.
Okay.
I felt at the start of the mediation, the introduction process, after the mediator had spoken, I felt there was an imbalance in the whole process at the start. Because I felt that KNC was not saying much. A lawyer was doing all the talking, whereas on the other hand, this put Singh company in a bit of a, I would say, a difficult position, or I think he felt, oh, this is the lawyers talking, this is a courtroom, rather than a mediation process. And I applaud his lawyer for saying, yeah, you can say what you want. And I think that's what mediation is about. It's about allowing the parties to do the talking rather than lawyers, because then you will be able to understand the issues that has risen between the two of them. And the lawyers are there to simply assist in the position of his individual client in terms of the legal position of it. And that's my observation.
That's a very good observation. So can I just, before I go back to Lawrence, because I'm sure you'll hear a lot from Lawrence later, does anyone have a suggestion to how, if you were a mediator, how you would handle that if one party's lawyer starts talking a lot? Just anybody. There's no right or wrong answer. Well, there are right or wrong answers, but we won't hold you to it. Anybody has any suggestion? You do it. What's your name?
Hi, I'm Clara.
Clara.
Okay, just been to mediation recently where Chai sat in, actually.
And yeah, I think during that recent mediation, one thing I thought worked well, although I was a little bit taken by surprise, was for each party to have a chance, each person present actually to have a chance to speak. Yeah, so there was a request by the mediator. I was a bit surprised because I wasn't expecting to have to address the mediator, but the fact that each person gets to speak, like, what are you here for? What are you hoping to achieve? That actually helped perhaps diffuse or create a situation where that imbalance is less likely to arise.
So Clara is saying one way to hear less from the lawyers and to hear more from the parties themselves is for the mediator to take the initiative and say, we'll get to all the facts later, but perhaps you can tell me in your own words how you feel about this and what you would like to see achieved out of this mediation. Is what you're saying? Yes. So does anyone have a different suggestion, different answer? Right with you? Hang on. Help me with the mic. Running all over the room. Come over here. What's your name?
I am Shanti Abraham.
Shanti, okay.
I'm sort of in the middle of a mediation right now. I should call it shuttle mediation. Just a few days ago, we had the day one of mediation. And I like Lawrence's magic question of what do you want out of the mediation? But I think a lot of it cannot be prescriptive because in the context, it was a construction mediation, my first ever. One of the client as such came in with a lawyer, expecting the lawyer to do all the talking. And I think I would have changed the dynamics had I insisted or said, tell me what you want, because he would have given me a one-word answer. When we came back for the second day, by that time he had already gotten comfortable with the whole mediation process, and I think that's something we have to bear in mind. Not everyone comes into a mediation understanding their role, and it sometimes might take maybe not even a few hours, but just even one experience for the person to settle down. And I'm hopeful at the end of today I'll get an SMS that we have reached settlement.
Okay, great. Great input. So I'm going to throw a spanner in the works right here and throw you a hypothetical question. It's all very well and good for Lawrence to say, right, can I just maybe hear from the parties? And these parties are extremely civilized as far as I'm concerned. You should have seen me when I play a party, I tell you. Okay? So, supposing a party were to come in extremely abusive, crying all the time, completely incoherent and all that, would you still have the same answer, Clara? Anyone else? Would you still have the same? What would have been the solution then? Do you want to say some more?
I was going to say different rooms.
Sorry, there you go. What was your name?
My name is Catherine. I'll call for a break.
You call for right at the start of the mediation?
No, not right at the start of the mediation, just assuming that they are still into the opening statement, they were talking and suddenly somebody just go berserk and start screaming and all. I will probably call for a break. I say maybe it's time now, we take a break, and then I just make the person go out for tea or coffee and of course seeking the other party whether they are comfortable with this arrangement.
Yeah.
So this is what I'll do.
That's one way. And Catherine would call for a break.
Can we hear from Lawrence?
Okay, Lawrence, also answer those two questions,
Post me the first question.
The first question is, if one party were to come with a lawyer and the other party cannot afford a lawyer because these lawyers are just too expensive. People like Amolat, too expensive. So he comes without a lawyer. How would you handle it? One's got 4 lawyers, the other one's got no lawyers.
Well, it rarely occurs. I've not yet actually come across a situation of that nature in commercial arbitration. And but if I were hypothetically that happened, I will of course use the same technique. I will do no different. I should treat them the same way. The fact that one party have 4 lawyers and the fact that you are unrepresented does not mean that you'll be given less time. You'll be given the same amount of attention. In fact, I should be assuring him that I'll be giving him 4 years and not 2. Yeah, and assure him that don't worry, we're here not to say who is right, who is wrong, who is stronger, who is weaker. We're here to see a solution which we all can contribute to by value propositions. So it's something that I don't think we should be very different.
So you would, in other words, you would assure the parties that they are still the ones, regardless of whether they have lawyers or not, that they are still the ones who would own the process,
and the solution if you were to reach a settlement. But would it affect your attitude? Would you want that party to speak more rather than the lawyer, just to equalize things?
I actually have personally no preconceived idea or notion that who should speak first. I don't care who speaks first. I treat lawyers and clients the same. If your client wants you to speak, I'm not about to say that you don't speak, you speak. No, I don't. Because it's your process. If they are comfortable that lawyers speak first, fine. At some stage, she will speak. She will be speaking. I'm quite sure throughout this. I'm quite sure she will speak. Right now, she's more comfortable for the lawyer to speak. So I shouldn't change that dynamics. The working between the lawyer and client is a very sensitive one. I can't insist that you shut up, you speak. I will spoil their game, and I may lose his confidence. Whereas on this side of the table, he's very confident that the client is not going to play himself up. Yeah, he's very confident, he's been briefed, and he knows, so I'll leave it as that. Anyone can speak. And I won't regulate, I will not say that it's the layperson who's better for a layperson to speak. I don't think so.
So that's a good example of how every mediation is different, because all the characters are different, the dynamics are going to be different, the situations will be different. Okay.
Can I weigh in as a party?
Sure.
The brief that we had was such that there's a cultural issue as well. I'm a foreigner, I'm a Korean woman. I would probably be loath to speak in front. I might speak to him when we go into caucus, but right here I was rolling my eyeballs, I was trying to control myself. Just because the mediator asked me to speak, then if you want to talk about balance, I would not have spoken. I might have just, be my, yeah, I might have.
That's an interesting twist. Did anyone realize she's Korean? It's funny, actually. I've known Korean women to be extremely outspoken, especially on airplanes.
And the traditional sort.
Oh, the traditional, okay. No nuts here, no nuts here.
I also have the practice of, the same practice like Clara said, I'll always ask the non-speaking one if they have anything to add, so that they will be given the opportunity to say something. Even say or agree with everything my lawyer said. Or even to say, no, I just want to cry. Fine, that's fine.
Okay.
Right.
So you wouldn't call for a break? You just pass a tissue?
If we're so like if you do, then the way you do it, then of course I'll call for a break.
Okay, Amolat.
I just want to add a small observation. That is that as lawyers, we always tend to take a position. So when the opening statement was being made by the other side, he was repeating his positions. And we all know that in our mediation, you have to move from position-based to interest-based. So I think it presents to the mediator a little more difficulty if lawyers are taking that lead. So I think it would be good if lawyers can bring their client. I mean, the fact that the other party is a Korean woman, I think it's non-starter, because the Koreans have a president who is a lady. She couldn't be making hand signals. You're speaking
South Korea. South Korea. Let's.
So I think that was my observation, because it may make my client think that he's being accused of a lot of things, misrep. If it's any consolation, when a lawyer speaks, the other party should not feel intimidated, because half the time lawyers don't even understand what they are saying themselves. So that may give some consolation.
I think culture aside, I think if my personality was such that I wasn't comfortable speaking with everybody here, then, who would have noticed that too? Yeah.
Well, okay. Well, just keep in mind that the other question was whether or not you would have spent too little time in summarizing something, or could you have spent more time summarizing it? Would it have been clear enough?
I could have spent more time summarizing. Yeah. But I was also doing active sifting.
Active sifting.
Sieving. Yeah. And filtering away some of those things which I think will not be helpful, putting it up. Yeah. I acknowledge them, but I will not put it on the agenda or summarizing. I don't want to reinforce certain things. Yeah? For example, when they were upset about stealing, I don't say that you've stolen stuff or what. I simply say you have some concern with your staff leaving, you have some concern, and you are very happy. you need some staff, you know. I was actively seeking out some of those things, filtering it out.
I was also guilty because I was hurry up, Lawrence, because we had to keep to a certain time. We want to get to every stage. Okay, so I think in a normal setting, you would see more time spent. Of course, this is an artificially compressed setting, and so some of these things. But it was a very, very good observation for me. Okay, so yes, I have a question. Oh, here you go.
My name is Gopal. I think that has trained me, so I think I'm from SIMC.
Okay.
The mediator did not make an opening statement that confidentiality, and so much so Richard has to come back and say, is it confidential? I think it should have made it very clear in the onset, all matters spoken here are confidential. So I think the opening statement should be more straightforward than that.
Actually, to be fair to Lawrence, is that I deliberately said that. I think Lawrence would probably have addressed that towards the end of his opening statement. I think I sort of jump-started it. But valid point.
Yeah, so, and it happens in mediation. People come in with all kinds of things. You have a nice script in front of you, but you just have to roll with it. Yep. Here you go. Thank you, Gopal. And your name, please?
I'm just wondering, how come Lawrence repeated a couple of times? I haven't done arbitration, I haven't done mediation for past 2 years. Why was it mentioned?
It was deliberate.
He's trying to play mind games. Okay, but what was the point of that mind game, Lawrence?
So that I want to make them think that they have to help me to work towards a solution. Yeah. Very often we say how experienced we are, build confidence, right? Yeah, but now that they know that I've done a lot of mediations, I'll tell them, oh, I need your help more than you need mine. I switch, I turn the other way around. Turn it the other way around so that they will be more active than me. Yeah. So you can use this with different people.
Again, every mediator is kind of different. I've seen mediators go quite authoritative, very headmasterly kind of demeanor. Right, you must respect the process and you must respect me as your mediator and you will behave yourself, okay? And then I've seen people who are, please give me face, don't mess. So different, work with your own style. I'm sure, Lawrence has his own style and he does it differently for everybody. So if you have any other questions, they're great. We'll take one last question, and then if you have any other questions, write them down, and we'll have another chance to break right after the next segment. Yes, lady. What was your name?
My name is.
Take my name.
Okay. What was your name?
My name's Hanneke. You refer to the caucus, the private session, and I can see that in the diamond they're placed quite to the bottom as part of the problem-solving stage. But I can imagine that in particular, mention the issues that you pointed out, that you might feel uncomfortable speaking your mind. Isn't that a bit too late? Wouldn't you also find space, room for a caucus in the fact-finding part of the mediation?
We have only gone like 30 minutes, 25 minutes. We are, in real case, I'll spend maybe about 40 minutes at this first session. Yeah. And, but I will not call for caucus yet. I'll probably not go into caucus to address the issue. It will be much later. In fact, I will resume probably with continue the mediation, set the agenda, so that everyone will be focused on one sheet of paper, a few items that we'll focus our attention on, and I'll go into caucus. And of course, during caucus, before splitting the caucus, there'll be something else out.
Let me just weigh in on that. This is a common model. The model, of course, the mediator can differ or move away from that model if he thinks it's appropriate. And of course, in certain cases where parties are extremely emotional, or where maybe there's history or certain discomfort between the parties, the mediator may say, let's go straight into private caucus. So it's a framework, and it depends on the person you choose. Also, so all these dynamics are actually taken. So it's important in some countries, actually, in fact, some law firms actually have litigation lawyers, and then there's a group of lawyers that's devoted just to doing collaborative work. And so when they go into mediation, the law firm hands over that file to the other department. And when they're done with it, if it doesn't resolve itself, it goes back to the litigation lawyer. So in some countries, it's gone to that level of sophistication.
I would say as well, let me just weigh in. This is just a general guideline. But the real guide for how the process goes will be dependent on the parties, the dynamics, the problems, the emotions, everything weighs in on that. There are mediations that conclude very satisfactorily and end up in a settlement without parties ever having gone into a private caucus. If they can talk and the mediator can navigate the muddy waters really well, you might end up that way. And there are parties that do not even want to look at each other, start crying from the start, and they can't even face each other, and maybe you have to break, like Catherine said, break for caucus quite early. So this is very much a guide of what the stage should be like. And of course, a private caucus is extremely valuable tool for you when you want to dig certain things out that you feel there's a resistance there, or you want to control the parties in some way, or you want to reality test some of their demands. Very useful tool, but not compulsory, not mandatory, and it doesn't have to happen or fall in that. It just so happens that we're going through the normal stage right now. Okay, so we're going to move on to the next stage. You know we've stopped at summary here. We're going to zip through a little bit of agenda setting and then go forward. And there will be an opportunity for you to make your observations and ask questions, okay? Thank you. Over to you.
Thank you.
Play.
Thank you very much for sharing with me all your concerns earlier. I was just thinking that it might be easier to just put some points up on the board so that we can focus on what we're going to discuss here, continuing in our joint session, or we can go to the conference if we feel more comfortable. So I've sort of put up on the list here. Casey is very concerned with the sales figures. Yeah? And they're also very concerned with the departure of the employees, and you're also very concerned with new products that the Singh is developing, and of course, as a result, they are afraid of competition if they are going to market those products, independent of the JV. Yeah. And you mentioned also of very crucial importance to you is the technology aspect, the patentability aspect of the product. Am I correct in that summary? So these are the areas of concern. Singh, on the other hand, also have concern with sales. I think his desire is also to see expanding the market, right? You would like, of course, to see sales going up. And so here we see there's a commonality in interest here. Yeah. Secondly, you also have a staff issue here. You of course need staff, but you don't know why staff is coming from KC, so we're happy to receive them. So you have a same issue, but maybe different interests there. So we'll see how we address that. Yeah? You are interested in developing new products, teenage products, yeah? And again, this is something that KC has been doing all these years, and maybe we see whether or not, yeah, you don't see an area of competition, but you do see it. So let's see how we put this on the board and see how we move from there. Of course, you are interested in patenting your product for the teenagers, so that is again, there's some common interest, but again, there's some tension in terms of these items we see. What I think we can do is to identify, here we have one issue, one thing we can discuss. Yeah? See whether there's anything that we can work towards. Here again, as well as the staff, you have a common interest there in terms of how staff move or to be deployed. The new products and competition, can I say that these are actually essentially the same issue? It's related to the same issue of products, right? Products, patents, so basically there are only three areas that we should look at. Should we concentrate on these three and discuss and see how we can move there? Yeah? Yes. We can do that in joint session, or we can break up into our office anytime if you wish. In terms of sale, maybe we just talk about sales. How can we improve sales? I understand that prior to the signing of the agreement, there is some sales figures that are proposed, and of course, KC is saying that this is below what they have projected. Is that correct?
I think we would like to hear some explanation as to why those figures have not been met.
So far apart in actual fact.
Exactly. I mean,
because the reason why we came into joint venture is that we are already very bigger name in Japan and Korea. And they claim to be big in Southeast Asia. And they gave us all these numbers that they can achieve. But there is no achievement, not even half of it.
We heard from the sales director of Singh Limited earlier, but I don't think I heard in his explanation as to why those figures have not been met. I mean, I think he explained that the figures were arrived based on certain considerations and so on. But I don't think...
The market. There's nothing wrong with the market.
So I think
in order to buy other brands, not
okay. Yes, Mr. Lam.
I mean, you know, tell me who guarantees sales and revenue? Can you guarantee? Can you guarantee? You don't, right? I mean, all I do is that...
we rely on to come into the joint venture.
Am I talking or are you talking?
No, nobody's talking about guarantees.
You wanted to continue first?
Listen, just give me a moment. Let me hear from him. Because I understand that sales figures, both of you agree that sales figures are below what was anticipated earlier, right?
Yes.
Maybe Mr. Lam.
Yes, sir. You know, I mean, when the joint venture was entered into, I mean, as she has rightly said, we are big in Singapore, Southeast Asia, and you know, in the region. So of course, I'm just a sales director, right? And when the numbers were supposed to be done, to be declared and represented in the joint venture agreement, so I depend on my auditors. My accountants prepared it. I depend on what they tell me, and then based on that, I provide that. Of course, that is at that point in time. As you know, in the last couple of months, so many things have happened in the world. Supply chain has been disrupted. There's so much disruption. The economy is bad. Stock market goes up and down. US dollar goes up. You know, all these things all happen. They all affect trade. I mean, I can't control that. I give whatever, to the best of my information, knowledge, and belief at that point in time, whatever that was correct.
Let me ask both of you, do you want to discuss the marketing plans?
I mean,
the reason why we joined venture is that they are the marketing experts. So we rely on them. It's almost blind faith. So I would like to discuss, especially now in their performance, but look at him, he doesn't listen to a thing I say. What's there to discuss? It's hearing him talk.
You don't understand, they speak Korean all the time. You know what I mean?
So if I could just weigh in as well.
Okay, gentlemen, I think maybe at this stage I will see you in caucus.
I think so.
Maybe we'll just look at the caucus.
But what about the other two issues?
I think we can discuss that. Do you have something else do you want to say something on any of the issues?
I mean, okay.
Or we can do that in caucus also. Or we can continue with the other two items and then whichever you like.
I'm happy to do caucus.
Okay, so
there's something I want to tell you in private. Yeah.
Okay. Can I, who wants to spend time with me first for a short while? Just discuss something.
Ladies first.
Well, so I'll start with KC then. In which event, I'd like you also during the caucus session to think about some of these issues, like what I asked earlier, the marketing plans, think about something we discussed later, what about the patterns and how we're going to do the staff ratio out there. Things along those lines. The whole idea of this mediation is for both parties to see the problem is not their problem, your problem, our problem. So it is a tension that we are in the joint venture, so you want the joint venture to work. I'm sure both of you want the joint venture to work. So if that's the case, let's think of how we can put value propositions to make the joint venture work. Is that okay? Yes. Okay. So during the break, don't do nothing, don't go for a smoke. Don't think about these things.
You need a smoke.
Okay, then we'll switch it. Yeah. Maybe we'll sit here. Huh? Is it okay? Then you two go and have. Yeah, you can go. You can go there and sit down. Okay. Thank you so much.
So just before we begin,
yes. Let me just confirm that whatever you tell me in the caucus, I will keep it confidential and not disclose it. But if I think that there are areas or points that we should disclose as you can bring better understanding and better value to this session, I will tell you with your permission.
If I can just point of clarification,
yes.
My client has requested that we obtain from you before we delve into this session.
Yes.
And even in the course of your opening, you explain the process of the mediation, and you outline the possibility of parties proceeding to a private caucus or private session. I think that's where my client has some, not difficulty, but wants a better appreciation of what the session is going to cover and entail. Because I think my client had come to the session today thinking that mediation was going to involve all parties at all times. So this whole idea of breaking away and just speaking to us in private, I think she is trying to better understand the purpose of that. Is it a session for her to share perhaps some secrets with you or some things that she's not comfortable with saying in a joint session?
That's a very good question. I should have explained this better before we break up for this caucus. The purpose of this is so that we can, because I do feel that sometimes in a joint session you may not feel it's a liberty to say certain things to me. So this caucus is for you to share with me certain things that you would rather not talk about in the open. So it's really for me, more for me than for you to understand your case, understand your interests, understand your concerns better. But if you're uncomfortable, I can always come back, go back and join session anytime you want to. For that matter, anytime you can go back and call off this mediation if you like. If you find that we are not moving anywhere, we are not giving value, you can move on anytime. Feel free to tell me that. Be brutal with me, as I will with you in caucus.
It's a relief that I can speak my mind, because I was very, very uncomfortable just now with everybody. And if you've seen how Mr. Richard there behaves, it's very against my culture to be fighting in public. Well, especially me personally.
Yeah, go ahead. Let me not.
This is very difficult for me. Okay, I'm not only the CEO of this company. Okay, I was the co-founder. I was involved in the research and development. The products actually carry my blood and sweat. Okay, there he is. He just goes on about numbers and who can guarantee the market. That was not the spirit of the joint venture. We came in with a view that they were going to help us grow. And the reason why I needed help was I'm so vested in this company and this product that I've spent every cent I earn. I told you we were making money in Japan and Korea. And I've spent every single cent earned on further research and development. And we are probably going through breakthroughs now, and my counsel has advised. We were so focused, we haven't had time to go and look into the legalities and patents, because I believe so much in the company and the product. You know, there he comes along, supposed to just sell my product. Now he wants to steal the technology. He wants to get my people to go work for him. It's reprehensible. I mean, where is the trust? You know, what he said about the staff. Oh, how can he stop people from going to join him? If you were my partner, if my staff offers to come, you say no, thank you. Isn't it? That's what I would do if his staff came to me. I'd say no, thank you, especially since his sales staff are quite horrible. These men have no idea what real beauty is, what cosmetics are about. They just all his salespeople are guys who does wholesale, probably never even opened a box of product or smelled it. You know, so it's very difficult for me, who believes very strongly in our product, to deal with someone who's all about numbers. And the worst part, he says he's a sales director, and he asks his accountants to come up with sales projections. Where in the world? You know, so I find it very difficult to continue.
Tell me more about the joint venture. Is it making money? Or are they losing money?
He's not making money because, you know, he's supposed to be an expert with Southeast Asian market, but nothing is selling here.
Is the company losing money?
So if I could just weigh in here. See, I think where the client has some difficulty is this. On the one hand, the JV itself is not making money, as you can see from the sales figures being so low. But on the other hand, we have Singh Limited, in a sense, using our clients' employees, having them join them, and then wanting to launch a new product line and develop, in a sense, compete with JV. So that's why we say fundamentally it just is at odds with the spirit of the JV arrangement. If that was what Singh Limited intended to do, I mean, why could not that have been pushed with the JV perhaps? Instead, Singh Limited seems intent to want to go at it on its own and compete with the JV. So I think that's where we think there is an issue.
When you say that the sales, if I come back to the sales projection, which is the first item of the report, we should focus on, I'd like to talk about. I asked you earlier whether it's making money. That means, is it profitable? Is it a viable business, or is it going this way? Is it going down the drain? So what do you see in this JV?
If it goes on this way, and then on top of that, they want to go and compete with the JV, will be over in 6 months.
So if there is no competition, what will be the scenario?
Even then, if not meeting the sales targets, so much so that, can I tell you something very confidential that you're not going to tell him?
It's up to you. I mean, I won't tell him if you want me to.
This is strictly between us. I mean, my lawyers know, but the JV actually has been asking me to put in further funds, which under contract I'm supposed to do. But I was hoping that there'll be some returns from the sales and therefore I can plow it back. But right now, without those sales, I have no money to put in. And with all my money put into the R&D, which now he's trying to steal, I really don't know what to do. So, if you ask me, the JV is doomed.
How does it come to that situation? Is it because the JV sales is unable to support its operation, or is it because both of you are not both parties are not putting in the capital to make it work?
I think the sales the assumption. I mean, when we started the JV, the figures on the basis that we'll make certain sales, and then with shareholder funding, we should be able to be breaking even soon. But that's not getting there at all because of the sales not meeting the target. Yeah.
I think the point is that we're not on the ground marketing, selling the product. We came into this on the basis of certain projections that were put forward to us. Singh Limited is on the ground marketing these products for us. So obviously the sales haven't been that great. And I think the point that my client is making is if it continues along this route, JV doesn't look like it will survive.
Help me, Mr. Selvaraj. You are the one who is very familiar with the contractual provisions between the two parties. Is there an obligation on client's part to pay some money into the joint venture?
Yes, there is. We are legally obliged under the contract to put in a further tranche of capital payments. That is due on a particular day. As things stand, it looks like we're not going to be able to meet that demand.
You are not going to, we meaning
outline.
JV?
Outline will not be able to meet that capital input. But in a sense, it's a catch-22 situation, as my client said. We are in this position because the JV isn't doing well. We had hoped that some of the sales would, in a sense, result in profits.
And they'll move away no need for this capital injection.
Well, yeah, I mean, if we will
postpone the capital injection.
Either that, or if we were making healthy profits, we will then, in a sense, draw dividends out of that and perhaps put it back into the company.
So maybe can we sort of pretend that this discussion has gone on for some time, and then maybe let's say, Lawrence, you wrap up and they want to now think about some of the things you said, and then just call in the other party and then we'll stop there.
Yeah, okay. So, well, let's go down to the main concern you have. And that is, if I understand from you earlier, now this long discussion for the last 3 hours, we've been talking about the staff not being able to work with them. perhaps there are some things, and we'll also discuss, you're quite open to your staff teaming up in specific teams, specialized teams to go with the male team, so to say, the male and female, mix them up into different teams, and some retreats and some company functions, we put them together, or some boot camps so they learn to work together and better understand. We also have discussed on the fact that your fear of patent, or the patents, or your know-how is being stolen or registered, but you are quite prepared that if this reside in the JV, you'll be happy with that. Is that my understanding?
No, I think what is my baby? The technology, I have to have it. Okay, can't see me to keep it. But we're happy to license it to the JV for production of products that will increase our sales.
So for those new products that you have been working on, your staff will be working on.
Yeah.
You want to retain the intellectual rights, the IP rights. You are prepared to have a license to the JV code and then market it with their expertise in marketing. Is that my understanding?
Yes, so, and insofar as this new product, Singh Limited, intends to roll out, I think we discussed that preference perhaps is for that to be something that the JV embarks on. So rather than Singh Limited go at it on its own, we do it as part of the JV.
Hopefully.
Yeah.
Then help me then with the other part, your obligation to put in the capital, which I'm sure they will be quite keen to hear how your proposals are. How do I move them?
I think with the new structure.
Okay, we can't talk about all those details. So
Okay, we're going to press pause right here.
Yeah.
The fast forward didn't work very well, the button. Can I invite the other parties to come back in? We're going to assume that this private session has gone on and he's gotten all the information he needs, right, Lawrence?
Yes.
Then now the other parties have gone on and they've also had their private session. Already done, sorry.
Sorry, fast forward.
No, Oscar.
No, I still have to drama just now. Okay. Now, okay.
Now your comment.
Okay, well, maybe so that some of you may be waiting to observe how the change of parties actually take place. So since we didn't actually demonstrate that, maybe lawyers just tell us what you have done after you summarize, and they say that that's fine. And then you say, can I bring some of these things across? And you tell them exactly what you want to bring across, and they say, yeah, that's fine. So then what happens immediately after that, before you call the other parties, and just describe it, and then we can take questions from the floor. Okay, describe the part where they've given you authorization to bring across certain information or even proposals to share with the other side.
Just like what Tat says, in the caucus session, what I was trying to do is to generate options, to understand their concerns. And I was patiently, I think I'm supposed to take 3 hours, but it gave me 13 minutes. So I'll take on through each of these main items so that I understand what their problems are. And of course, in the course of it, you hear that it's revealed their cash flow issues. Yeah, very kindly, I should be getting it from her, but she was very kind to reveal it.
Bursting already.
Yeah, yeah, and then I'll talk about the staff, and then having this. Yeah, of course, sometimes you're so happy you want to jump to them and say, hey, I've got a deal for you. Can you? But in my private session with them, I'll go through the same thing with them, examine each of these items and see whether there are common areas that we can work towards. And finally, I'll bring them together, and this is a session in which I will tell them that.
And for the benefit of those folks who have never ever seen a mediation, just a quick run through. Now, if you go back to the diamond, we stopped the first time at summary party B, right, Tony? Okay, we stopped right there. So what happened, as you've seen Lawrence do, was something called agenda setting. Now, we do this every time we've heard from both parties. And what's agenda setting? It's merely setting up a roadmap of issues, both parties, he's weaned out of both parties, that will be discussed and addressed and hopefully resolved throughout the process of that. Okay, so he did that, and this agenda setting, don't be tempted to skip it. Don't be tempted to skip it. Every single time I've seen people skip it, it's just like trying to put up your painting without actually having walls. If you skip agenda setting, okay? So it provides a roadmap for you. You usually do it on this big flip chart thing so that both parties can see. I find it very useful. Yeah, he's Steve?
Well, we'll normally write the agenda, and then we'll discuss for one party. And sometimes we use the same page, sometimes we flip a different page, so that sometimes the confidential stuff, we write it here, we go on the other side to see. So the same agenda items with different comments, and at the end of the day, we can put it up together and merge them if necessary. But the whole idea of writing, I think the important things of writing an agenda is the parties will not stray, but they will focus on these three items. Yeah? So the other ancillaries, like just now we say, that's why I sieve out certain things, will become irrelevant. When the main items are tackled, you'll find that most of the other items may not be relevant in the resolution.
Well, in my experience, you usually find two types of problems that agenda setting can resolve. The first is parties are very long-winded and tell you all kinds of grandmother stories, and they will give you 100 points, out of which maybe half is relevant. And so that helps you to put it on. The other category of people, they come to you and they say, I only have one problem. There he is. Okay? Or I only have one problem, and then they present an extremely complex one. That makes it necessary for you to unpack, and it's actually 3 or 4 problems. And as you've unpacked it, you put it there, whatever you've unpacked. Then you see, hey, that one problem is actually an amalgamation of, world peace, whatever it is, in one solid piece of a string. Okay? And so the agenda helps you to do that. I found it very useful as well to kind of divert attention when parties are staring daggers at one another. When I get up and they look at the thing. So that's agenda setting for those of you who have never seen a mediation. So Lawrence did that. Then there's exploring of issues, and he lets them talk and ventilate and listen to one another, and it's an opportunity for him to assess, right? Can they keep on talking? Are they communicating? Are they listening? Is it time for me to break that situation and move them into a more private setting? So this is an opportunity for them to listen, to talk, to ventilate, and for him to assess. Okay? We had a question right there.
Yeah, it's just
yes, question. It's your name, please.
It's just a very basic one. I've never experienced an agenda being put on the board prior. I know we're in a capsule situation, but I thought part of our tour to SMC is that we work with the parties putting the agenda. We were brought back into chapter 2 with the agenda already being up on the board, which I found very, very strange. I've never done that, and I never would do that.
Oh, it's because we were fast forwarding it as we were talking. It's all because of timing.
Yeah, that's right.
And so,
that's my question.
No. You are absolutely right. What was your name?
Nikki.
Nikki, you are absolutely right. Mediators don't usually arbitrarily set the issues down by themselves. It's through input from the parties, but we have to fast forward, and I have to basically kick him and say, "Oh, okay." All right. Did you have any other questions?
Okay, let me bring you the mic.
I'm just curious, it's a small point, but prior to getting into a caucus, how do you set the other party's expectations as to the amount of time that will be spent with the party you're going with first? Because sometimes you don't really know how much you can disclose. But then the other party's waiting, wondering why it's taking so long. That just struck me.
Yeah, sure.
Usually I will, before breaking up, and I actually did that even before, I mentioned that sometimes I spend a lot more time on one party and less time on the other, not because I'm more sympathetic to them or that they are more problematic. So both you can interpret it many ways. So I always tell them that don't worry about that. I will come back to you. I certainly come back to you. If I take longer, then does not mean that I'm following I'm against them or for them. So I'll come back to you. Just assure them you come back to you. However long it takes, I'll come back to you.
The experienced mediator, I'll come to you.
Often I may even tell them half an hour, but it may be longer.
May actually, if you realize this, you need more time. You could pause for a moment and then tell the other party, I'm going to need a bit more time. So, maybe now 15 minutes I'll come back to you. So it's to keep the other party alive to the fact that something interesting is happening here, and the mediator thinks it's useful to continue plugging it. So the other side doesn't wait there wondering how long more. Let me come to you with the mic.
I would want to encourage those. I realize many of you here have already gone through your SMC courses, and you have this very good exposure to mediation and all that. Now, I would like to encourage those who have no experience with mediation, who may be business owners or lawyers or in-house counsel like myself, you don't have anything, as far as mediation is concerned, you are a Vestal virgin. Sorry, was that?
What did you say?
Yeah, you do not know. I'm sorry. We were going to talk about this video thing, okay? So you don't know anything about it, and I would encourage you to ask your questions, anything at all. And come forward, give us your observations, tell us whether this is something that you would see yourself or your organization actually being a part of later on. Yep, you had a question there? What's your name, sir?
I have a question. My name is Ray.
Ray?
Yes, I've never been through a mediation,
Oh,
so
okay.
I've been through arbitration.
Oh, okay.
So what I'd like to understand is in the setting of a mediation, when is the time that you actually look at the evidences or calling witnesses, or is that never a case in a mediation?
You don't. You don't. It is not a trial. We're not here to determine the facts of the law. Then you go for arbitration, for that you go to court. Here we're trying to find a solution, and you find that I will not go into the evidence. And sometimes lawyers will bring bundles and bundles, yeah, to show how strong their case is. But really, it cuts very little in coming to the solution. Yeah.
Because in a business setting, I mean, this example is actually a business dispute. So likewise, we are all representatives of some commercial organization. I think in cases like this, there will be some contracts or emails or something that actually says, okay, this is what you committed and this is what is signed in the contract. So I'm just surprised that maybe in this role play it is not meant to display that, or maybe it happened 1 hour earlier, where you actually show a contract and say this is what you committed. So that's why I asked about the question about showing evidences, or maybe even for staff, the issue of staff. Maybe there was an email that actually shows someone is poaching, right? Do we show that in the private session, or do we show it in the opening statement?
Well, can I jump in here and say something about that? All right. It's not that the facts do not matter. It's not that they don't matter. They don't have the same function as they do in a court of law, when the judge is trying to decide whether you're right or wrong and what is the fair thing to do. But they do matter insofar as how the mediator would use these facts to reality test someone's position. So for example, if she had a very firm and signed contract, and she had a very strong case if they were to litigate, but he is blind to that fact, and he's continuously asserting a demand that would be unreasonable. In the private session, and this is what I mean by a private session being a useful tool, in a private session, what Lawrence would do would be to reality test. Right, so there's this contract that she's showing. What do you think your chances would be if she were to take that contract to court? So the function of that fact is used very differently. It's used persuasively, it's used to reality test, it's used to bring them down, bring their expectation down to size. It's used for them to self-reflect. It's used to move them from their position. Okay, so the function, so facts matter, the veracity not so much, but the objective and the usage of the facts, I think, is what is more important in mediation. Because really, at the end of the day, he has a strong case, she has a weak case. But for whatever reason, she's willing to accept his proposal, and they settle. We are not here to say, hey, that was unfair, that was not reasonable, you could have gotten a better settlement. No. Willing parties, they settle for whatever their interests are. Maybe she gets a peace of mind. Maybe she says, better get this out of the way because my company is going to list in 6 months. You don't know that. Maybe, it's unfair, let me settle this because my company is going for listing in 6 months and I don't need this on my docket when I'm listing. Okay, so you don't know. So facts matter, but not the way they do in court. This is my input anyway. If anyone has a
let me just give an input and then we'll break for tea. Need some caffeine and some to live on Friday afternoon. The reality is many commercial cases often segue to mediation midstream through either an arbitration or litigation. And if you have that kind of environment, of course, it's somewhat different. Because by then, the parties have crystallized, mainly through their lawyers, their case theory. They have set out in their pleadings their causes of action. And so they know exactly what their legal framework and legal positions are. And in fact, it might come to a stage where discovery has taken place. So parties have in hand all the list of documents and the documents they have seen it, which are relevant to the case at hand. And in fact, some may even go further and have exchanged affidavits of evidence in chief, although that's relatively uncommon nowadays because people believe that if you're going to do that, you might as well go all the way to trial. But so it often takes place, usually I think between the close of pleadings and the exchange of lists is usually when a lot of commercial mediations take place. Now if you imagine that setting, this is where mediating the litigated case comes in, parties have already understood each other's legal positions. And they may then sieve out certain documents which they think are fundamental to the case itself. And then they will present that in the form of a bundle, send it to the mediator so that he understands that's the backdrop, the legal framework. So when parties sit here, they're not sitting in vacuum. They're not mediating with nothing in the backdrop. They are mediating sometimes with the law in the background. And some of these mediations, Lawrence talked about how we don't really have to deal with the legal issues, but some mediations are very legal-centric. And some lawyers call it mediating in the shadow of the law because the entire mediation adopts the framework of law as backdrop. And the legal rights are fleshed out in full. So it depends. But of course, the way it's conducted isn't so stiff and rigid as a court process. It is entirely up to parties, so party autonomy kicks in. Don't know whether that answers the question. You do have that framework, but up to the mediator, up to the parties, how they want to flesh out whichever documents they brought along.
The example,
sorry, I was going to say, it saves you time, doesn't it? When you do not have to have an expert to determine the veracity of every fact the way you do it in trial. And that's one of the beauties and the advantages of mediation. If I knew that I could spend one day to gamble on the fact that I might be able to walk away without having to go through an expensive, long, extended trial, I think I would gamble on that. I would say, okay, let's do it. And that is part of the beauty of mediation. You're going to say something?
Yes, yeah, I want to say something on the question you raised about the staff. If there's an email, if she has an email that he sent to the trying to approach staff, and she will show me in caucus. She'll probably show that to me in caucus, and I'll say if I can use this, I'll ask her permission. Or if not, if she doesn't give me permission because there's a secret weapon she wants to use in arbitration, I'll in my private caucus and ask him about it without saying that she has. So I'll test him. How did the staff come to you? Did you invite them? Did you somehow attract them to join you? What did you do? Tell me. And slowly I'll get out from him anyway.
So this is a good way for us to segue into what is a private session, and I'll do that very briefly before we break for tea, so that we have a placeholder here. The thing about private sessions, if anybody has any questions on private sessions, as you can see, it's a very useful tool. A lot of people are very reluctant to talk when the other person's there. Okay, I think I've had parties who try to curry favor. They find that a good time to kind of get the mediator on your side, because they keep forgetting the mediator doesn't decide. Okay, so it's a useful tool for you to find out more information. Every piece of information, whether it is from her body language, from the words that she says, or from little secret emails that she gives, is a tool for you. It builds up your little treasury, your little armory. It's information that will help you reality test and maybe bring the parties a little closer. And it's a tool for you to find out if there are any hidden interests there. The more interest you have, the greater the chance that you will settle in the middle of that zone. Okay, so does anyone have any quick question on private sessions before we break for tea? Okay, if you don't have any questions, if you do have any, write them down. If not, let's go for tea, and can we come back at 4:35? Thank you.
What we will do when we roll into this next stage is for Lawrence to move into the second private caucus. Yeah, so he's going to start with the second private caucus, and then after which he will move into the joint session, the second joint session. Okay, so he's going to demonstrate that, and then maybe after that we can see how things turn out. Okay, so.
Thank you. And Mr. Lau, I actually had a very good session with Casey earlier, and I must say that he's been very helpful. He moved a long way since the morning. And I understand that you want to see me again, so I'm very happy to see you. Is there anything particular that you want to tell me that maybe even more useful for us to do this?
Kamsahamnida. Thank you for seeing me. Did she say anything nice about me?
I must say that unlike our joint session, I think she's been very gentle. She's been very, very grateful that you have come for this mediation. And I get very positive vibes throughout the caucus session. And I see a bright light shining upon all of us.
Reflecting on our...
It was dark this morning.
It was dark. Okay, let the sun shine then. So what do you want me to
in terms
talk
of,
to you about?
Yeah, I think in terms of this area in which we have spoken about the patents, and I think you are quite happy about having the JV being licensed to produce these products and then jointly marketed by the JV. But concerning the only item that's outstanding is the satisfaction of the sales figures. Can you tell me about something more about that? Can you tell us why?
I mean, as
what do you propose to do?
As I mentioned earlier on, right, I had depended on my accountant to come up with the numbers, and they did it.
So it's a mistake, or
let me talk to my counsel. So should I tell you the truth? Yes, I think you're true. Maybe you want to.
I see. I understand.
Yeah.
Okay. Basically, I have advised my client on the.
So hang on. So when you do this, I think audience needs to know what you mean.
Yeah.
So fast forward, right? Fast forward. So where are we now? Are you?
Well, they were supposed to.
We have gone through. I've done a lot of probing, and he's now telling me.
He was supposed to have danced with me and tease out the truth from me, but I am offering to speed up.
He's about to just say something that.
Okay, very profound. Okay, so you know where it is right now, and okay, Lawrence, finish it up.
Maybe you want to let me.
Yeah. Okay, I'll let the mediator know. Okay, so actually the sales results, right? To be honest, they were based on my knowledge of the Singapore and Australian market. So for Malaysia, Thailand, I had sent out surveys, but those fellas never responded to me. So I actually guessed.
Anyway,
slightly distorted, but
moving forward, you are prepared, of course, to share your marketing plans with them, and also in terms of staff, you are not going to you're going to let them stay with the JV, right?
Yeah, and on top of that, I think my counsel has also advised me that in relation to that sales figures, I think we have
Yes, I have a problem. I told him that there is misrepresentation. If we go to court, he's going to lose quite badly, and that's not very nice. And we don't want to make the Korean woman so happy about it.
I'm glad to hear that both sides are on the same page that we should not go to arbitration or court. we seem to have seen, I think we have come to some possible solution against it. Roadmap, as I see it, is that, as you have already shared, that we're going to go back to joint venture, make it work, come up with fresh marketing plans, involve them in the planning, involve the staff retreats and training for marketing of these products. And that in terms of patent, you're happy that they retain patent rights and it's licensed to achieve the goal. And in terms of the capital injection, you're also happy that this matter that they will be deferred because of the initial filing.
So as long as you don't sue me for the misrepresentation, so that is, to me, that's critical. I can't afford to go into litigation.
Thank you. I think it's about time we call them back and then we'll probably wrap this up. And I hope at the time I would invite you to share what you say, what you've said to me. Okay. Hey, ladies, come.
Ladies.
By the way, this is Selvaraj. You're also welcome. Well, it's been a long day, but thank you. Thank you for your patience. I think we have come a long way since the morning, and I'm pleased to say that I think we have forged a pathway ahead. So maybe I invite Mr. Lau to say something. In terms, let's just go item by item. Say, in terms of sales, right, the proposal, and see whether this is the understanding of the
Okay, as regards the sales, my client's proposal is that we continue with the joint venture. It will invest in marketing resources to develop markets in Indonesia, Malaysia, Thailand, and for the shorter term, focus on markets in Australia and Singapore.
They'll be involving, they will be discussing with you the marketing plans your team will involve as well.
We could work out the administrative details mutually, but this is agreed in principle. I understand that you can also raise this proposal.
Yeah, I think broadly, yes, we are in agreement. But yes.
This will be achieved within the next 3 months.
3 months, yes.
That's my understanding. Is that correct?
And as far as the staff, that was the next issue, are concerned, my clients agree that the employee, especially your R&D employees, will remain with K&C.
Yes.
In fact, my client wants to make it clear that there was never any poaching, but we have passed that stage. The agreement is that he will remain. And as regards, we said,
I think that is ideal for us. But just in terms of enforceability, I mean, we're talking about the R&D employees remaining with us. I mean, the employees are not before us in so far as this mediation is concerned. So, just one query that we have: how do we get them, in a sense, bound by this settlement if one is reached?
If I understand, is there a fresh contract with the employees?
There is no fresh contract.
So remain the employees of PLC?
I assume they have not signed new contracts with...
No, they have not.
And insofar as some employees have intimated to Singh Limited that they wish to join them, how does your client intend to deal with that for the purposes of the settlement?
I think if we agree to it here, then we'll just stick with the agreement.
And that they will remain.
Which means they must pledge not to take on any of our
this. I think if I understand
So, but to be fair, only Singaporeans see the pledge.
Confident not to take my employees.
I understand that Singh's position is that they've never signed contracts with the staff. Of course, it's a new staff.
Singh and Singh Limited.
Yes. Singh Limited have not signed any contracts. Any contract with your staff. And as such, it remains your staff. And if anyone, of course, they want to resign and leave this beyond their control, right? Insofar as they want to stay, they can stay, and then work for the jointly as your employee. Is that correct?
Yes.
Yeah.
So the other point was
the R&D patents. Yeah.
As far as the patents are concerned, my clients are agreeable that this will be developed in the JV itself with a license for KNC's technology and sold through the JV's distribution network. Yes, development by the JV.
The technology stays with me, right?
Yes, the patent rights stays with you, yeah. But then they jointly develop the product, and then they will market. And the KC will license it to the JV for the purposes of marketing.
And we will have a say in the marketing as well.
Yes, just like from the beginning. No, because now we have.
It is a new beginning.
Yeah. It's a new dawn. It's a new dawn. A new era. And the last point was about capital. I think my clients unanimously agreed to give you some time to put in the money, maybe within the next 6 months.
Is 6 months enough?
6 months is good, yes.
It's good enough?
Yes.
That sounds good.
So I think those are the main terms.
So at this stage, I'll just summarize again what we have reached. Your parties and if I understand you correctly, we have reached in principle agreement, subject to what we are going to get the two lawyers to draw up the second agreement on the following terms with our Okay, thank you.
All right, let's give them a hand.
Wait, let me ask this. Are you happy?
Yes.
Are you happy?
Delirious.
Delirious. Okay, very good. And Lawrence, how are you feeling?
Yeah.
Okay, happy laugh. Good. Okay, great. So we've come to the end of this mock mediation. Now, can I request all the very famous actors, actresses here? No, stay. Can you just turn your chairs to face the audience so we have a little brief panel? And now I'm going to invite the audience to do something different here. I'll consider us all on stage here to be your resource for any kind of questions that you might have. Especially for this lot over here who are very familiar with the cases and how they felt throughout the process. Feel free to throw bouquets or tomatoes at them. And also all kinds of questions that are awkward or otherwise. Okay, so we are all here going to be the panel for you to kind of ask. Okay.
So anyone has any questions that you might want to ask, any specific one here?
Okay, now that you've reached agreement, and I suppose the lawyers will write out the terms and sign it, what happens after it's signed and you go back and one of you changes your mind? How do you give effect to the document?
Okay, who would like to answer? Actually, how about this? I'm going to take 3 questions at a time. That way we can do that quickly. And I also encourage people who have never done mediation, who have not sat for the course, who don't know, business people, commercial people, whoever it is, if you haven't had an exposure to mediation and you have burning questions, this is your chance. This is your chance. We're going to collect that. So how do you enforce a settlement agreement after it's been signed? That's one question. Okay, another one. Right here. One question. Thank you, Taz.
Is mediation suitable for me if I'm not willing to compromise at all? And have you ever reached a situation, have you ever had a case where one party, have you ever reached an agreement where one party stays firm insofar as the stand is concerned, and has not moved at all at the end of the mediation?
Okay, that's a good question. That means, let me paraphrase that and see if I am enough. So the first question is, how do you enforce a settlement agreement after that? And the next question is, if one party is refusing to move from his position, is it possible to reach a settlement? Is it possible in your experience to reach a settlement? So that's 2 questions. One last question, and before we open to the panel.
Hello. Very specific to this case, might not be in mediation in general, but after what you have gone through and so much of animosity, do you really feel you can work together again and with the same amount of trust
with each other in the long run? Do you really see that this is a comma in your journey, or it's a full stop?
Another very good question, and let me see if I can understand your question. What you're saying is, we have always pitched mediation as an option that helps to preserve relationships, and that's one of the advantages. So his question is, in reality, do you think after all is said and done, you can still continue? Is it true? Does it pan out in reality? And how often do you find that the parties can continue to preserve the relationship, right? So that's our 3 questions for now. We'll open for more later on. Does anyone have any potential answer for that? I think we'll start with the panel first and then we'll open to the floor.
I think it's answering all the law questions.
You know, almost everyone here is a lawyer, right? Yeah. Including you, okay. All right, Claire.
I have one answer to question 2 about parties not moving. Have you met George Lim? He will mediate for you and get you moving.
Yeah.
Yes. George Lim just walked into the room. It feels like Elvis has just entered the building. George Lim here, if you don't know, he's a senior counsel and he's also the grandfather of mediation in Singapore, okay? And that's not in reference to his age. Okay, actually, yeah lah. I'm sorry to say that. Okay, but yeah, okay, anybody else? Okay.
For the first question, can I attempt this answer?
Of course.
Now that Mr. George Lim has come into the hall, I suddenly am reminded of the case where I was the private mediator. Mr. George Lim was counsel for one of the parties, and there was another very senior lawyer acting for the other party. It was a matrimonial dispute. And it was also done in this place, so this place has got memories for me. After the mediation agreement was reached, and I think we worked very hard from about 9 o'clock till 6. And there was no typewriter, nothing. I wrote out the agreement in handwriting. And then I think the lady was the lady who changed her mind. She said that I don't want to be bound by this agreement. I want the matter to go back to court. And so it went back to court, and at first instance, the High Court judge tweaked it a bit. And this time, the husband wasn't happy, so he went to Court of Appeal. And in the Court of Appeal, I felt very vindicated because it's in the law report. They said that I had done the mediation, the process was followed, there were many private sessions. And the interesting thing is, when I wrote out the agreement in handwriting, of course, along the way, there were some changes, some mistakes. So I made both parties countersign. And this was mentioned in the Court of Appeal's judgment that the agreement had various cancellations and amendments signed by both parties. So it cannot be that they were not aware of what they were getting into. And in the end, the court said that the mediated agreement should be given binding weight, or words to the effect. So they said, go back to the agreement that you had, and so the lady lost the appeal. So I think that is by far the highest authority we have, to show that a mediated agreement should be given conclusive weight. Like I said, I felt vindicated because the Court of Appeal looked at the process, and for that I'm actually very grateful to SMC for equipping me with the skills to be able to do mediation and follow the process.
Now, on the question of enforceability of the settlement agreement, I think maybe Eunice, you might be able to contribute something from an SIMC perspective. Just let the audience who are vestal virgins when it comes to mediation and enforcement of settlement, help them to understand what kind of mechanism in Singapore and all the courts we have to ensure enforceability of these
Okay, so a mediated settlement agreement is like a contract because essentially through the mediation process, you renegotiate and you come to an agreement. So under the law, you could enforce that contract like any other contract. But we are aware that after this committee that was looking into how to improve and grow mediation in Singapore, the Ministry of Law is now looking into a new law that will allow a party who has a mediated settlement agreement to apply to court and then have that recorded as a consent order. And that will be a way where you can directly enforce a mediated settlement agreement. But until that law comes into play, currently SIMC and SIAC have this protocol where a mediated settlement agreement can be recorded as a consent arbitral award, and that is particularly important for cross-border type of disputes where you might want enforceability overseas. So that would be an available solution at this time.
Thank you, Eunice. Did you hear that? Was there any follow-up question to Eunice's response? Clara?
Just okay.
Okay, Clara. That's got the extra mouth. Mic.
Okay, the question I have is this, because in this particular case, right, there may be, okay, some agreement, good faith to achieve some new numbers, right? But it's again, you know, if it's not achieved, is it really because the parties didn't follow through? So I'm just thinking, okay, in the mediation that I went for, that George Lim was actually the mediator, it was not so complex, so it was possible to actually conclude even the settlement agreement on the day itself. But in cases like this, you probably still have a lot of details to work. So how do you actually even make sure that, you know, you come to a reasonably firm and enforceable agreement? Because otherwise you might end up having a lot of sort of efforts, right? Reasonable endeavors type of language in there versus actual achievable numbers, which in the end if failed, it's not possibly because somebody didn't try.
Okay, so let me just paraphrase just what Clara is saying. And I think what you're saying is there are simple matters and there are complex matters. And in complex matters, there are a lot of moving parts. And so maybe the agreement would be 50 pages instead of the mere 1 or 2 pages, right? And you're saying, how in the world are we going to be able to draft a comprehensive settlement agreement at the end of the day, at the end of 24 hours, that will end up being enforceable? Now, I'm sure other lawyers will have other things to say, but to me, it's all down to clarity. If your terms are clear and enforceable, and your matter is rather simple, it doesn't matter if it is, I've seen a very complex matter reduced into 1 or 2 pages in the settlement agreement. No problems with enforceability. No problems with that. Of course, if you are giving a very unclear contract, it could be 50 pages, and you're going to still have clauses getting thrown out. It is as simple as that, it's clarity. But if your question has to do with who does the drafting, is that also part of your question?
Yes, the lawyers are the ones that have to come to some consensual agreement.
Yes, yes. So, I mean, if you pay Amolat Singh enough, I'm sure you can. I'm sure you can. No, okay, so any other lawyers want to contribute on this issue?
I think just to add on, I think in reality, we probably wouldn't be just going, oh, numbers. We would probably really have our spreadsheets, and I would be challenging his numbers. I probably have my own experts coming in. We might already have done that, but I mean, this is an abridged version. Sure. So I guess, that's, and again, I think to attempt that question you had on relationships also. Hope, and I think you went through that with us the other day, George, right? That, again, this is an abridged version, but if in the course of all our, Lawrence may have run 3 or 5 caucuses with me and him, and then at some point in time we would have softened. And in particular for me, who have a financial issue, I'm going to swallow my pride. So there would be a good chance of relationship building, or at least I have to learn to trust. But if at a second stage in our JV, business issues come up, no guarantee. And I think that's the point, that your mediation is not going to cover you for a day, but definitely you solve the problem you have right now. And that's what you want. You want closure for this particular issue. There may be issues coming up again later, nobody knows.
So I don't want to, yes, Ramesh, you had something.
Yeah, okay. I think the question that you raised is a very live one. And I personally encountered that myself. Not when I was sitting as mediator, but when I was counsel in a mediation. Now, I'll tell you how we approached it in that particular mediation. But first, motherhood statement, you generally want to try to arrive at the terms of a mediation agreement or a settlement at the mediation if you can. That is the ideal situation. The reason for that is the minute you let parties walk away with a view to arrive at some agreement on some term, I can bet you, once they walk away, they're going to mull over things, they're going to talk to people. Chances are they're going to backtrack. So ideally, as a mediator, with the assistance of counsel at the mediation, you want to try to get parties to put their thoughts down to paper clearly, if possible. But I think you're quite right in saying that it probably can't be done in all cases. So which is where sometimes you need counsel to sort of play ball at that stage. You want to possibly arrive at something that is known as an in-principle agreement, perhaps the broad terms of the agreement, with an agreement to heads of agreement. I mean, I think parties will appreciate that that's still not binding, right? It's still in principle. It's not a binding agreement as such, but it's better than having them walk away. You want to have parties reach some kind of an in-principle agreement first, but at the same time you work out very short timelines by which they have to work out those nitty-gritty, calculations or figures.
Because for me, the reason why I asked this was when there was an agreement, Chai's comment is within a timeline, So she emphasized that a couple of times.
Yeah.
And then her reasonable timeline may be very different from his reasonable timeline.
So we're back to clarity.
Yeah. But in that sense, you do, probably this heads of agreement would be a way to bridge that, where they can work out, okay, is it 3 months or a year, and then you land at half a year.
I'd say that happens more often than not, and sometimes you don't even have to wait overnight. After tea break, they come back and they change their mind. And that even when you have agreed, a lot of times I get tripped up by this beautiful word called interest. Suddenly, there's before tea break, this is the amount. After tea break, there's also the interest. And so I try to address all of that and not get tripped up by that. Okay. I want to quickly address her question because I don't want it to fall under the cracks somewhere. And your question was that, okay, is it possible, and have you ever seen a situation where parties have settled when one party is as stubborn as a goat and does not want to compromise? Right? Is that the question? And I don't know about the others, but I've actually had that happen once. They've settled and one party made very few concessions, if any. Can anybody guess why?
Because they have a very strong case. Very, very strong case. Right.
Yeah,
right.
That's a very good. Because one party was in an extremely much stronger position. That man was very angry, very rich, and was willing to, on principle, basically, run the person to the ground. Okay? So it is possible, but it is quite rare. Parties generally, the mediator should be able to move the parties, look for all these different interests to move them along so that at least some degree of compromise can be made. But at the end of the day, the other party may decide, look, it's in my interest to just put a stop to this nonsense. Okay, I'll cut my losses here, you take it, and then we have nothing more to do with one another. So that is also a valid interest, isn't it? Yeah? So that was question 2. I want to make sure.
Actually, most people go to litigation believing that they have the best case in the world. Yeah. And that's why they don't compromise. Bring them to mediation. They will change their mind after lunch. Most of them change their mind after lunch. They think they have a very strong position until they hear the other side. And that's why I have a new philosophy in mediation. Last time I'm getting the private parties come in, we don't want anyone else who's not involved because they add trouble to the mediator. I don't see that anymore. I see bring whoever you want, father, mother, grandmother, bring. If they can influence your thinking, bring them along. Because you know why? If not, when they sort of agree to a settlement and then they go back and the others will talk and say, why are you so silly, you agree to this and agree to that. And then they will be unhappy with the situation. So I'd rather have more people, so that they will listen to the other side's story. They'll feel the dynamic, how it changed throughout the day. Through the day, things change. They take positions, and then they change. They realize that, hey, I may not be so strong. You do reality testing with them. You tell them, what's your interest? Most people come to the table thinking that they're right. They want their pound of flesh. That's the kind of people you find in litigation. But once you go through the first warning, you find it will be different.
Yes. More questions? Yes.
During the process of mediation, do you give any legal opinion or use that as a tool, saying that your case is weak when you go to the court or your case is stronger?
Very good question. Are you referring to the mediator?
Yeah.
Mediator? Very good question. Now, let me just collect one or two more questions and then we'll go all that. One or two more questions. One or two more questions. Yes, in front. What's your name?
My name is Alfian.
Alfian, okay.
My question is, how useful is it to have a settlement agreement to cooperate instead of a liquidated sum? I contrast this against, let's say you agree for liquidated sum. If the acceleration clause to get summary judgment, if parties don't perform. But to cooperate, it's just quite fluffy, right? And then if parties do not cooperate, what next? Come back again?
So an agreement to be nice to one another.
Like for example, I think that the joint marketing terms, I mean, there's only so much you can agree on. But at the end of the day, if parties don't trust each other and they just can't work together, how useful is such an agreement to cooperate?
Okay, all right. So are we down to enforceability?
Back to it.
Back to how do you enforce or basically live out the agreement that you come to, right? It all comes down to that. So that's two questions. One more question and then we open to the panel. One more question. I'm going to go with this gentleman here, Clara. You can hold it and ask Laura later. Okay, we'll you can ask Eunice later as well. What's your name?
Sorry, my name is Edmund Burke. So the mediator is privy to all the private discussions. Can the mediator be compromised, for example, if the mediator is aware that one party is lying or is being fraudulent or if there's misrepresentation? What happens in that situation? Does he just leave the settlement agreement go ahead or does he have to withdraw?
You mean he finds out in the course of the mediation or he knew before that?
Because he sits in on the private discussions and he's aware that one party is just basically telling lies and doesn't intend to stand by what they say. So what does he do? Because it's meant to be in confidence.
Ooh. Okay, so is that three questions? What was the three questions? One was on enforceability.
Legal advice. First question is on legal advice. The other question is whether or not, what's the use of a settlement agreement that has a continuing obligation to perform, not just a clear payment or act to be done. And the last question is on confidential information relating to from one party, for example, fraud or crime.
Let's go further than lies. Let's say he's committed a crime or done something illegal and he's wanting to do something illegal. Okay, so we have a very active this side of the room. I'm going to make an exception and take one question from this side of the room. Oh, okay, all right.
I do mediation, Community Mediation Centre. So, at the last clause in the agreement says it's enforceable the court of law. Question number one. So, I think it's, you say that, I just want to say that it's stated very clearly it's enforceable in the court of law. The second thing, the settlement agreement is prepared by the mediator. In this instance, you get the lawyers to, so will there be a lot of time wasted, each one trying to defend the other party, whereas the mediator is a neutral party drawing up the settlement agreement. So I just want to comment on this.
Okay, so we have 4 questions. Now I'm going to open it to the panel, and of course, if anyone here has also any other comments to make, to contribute, and input to give, jump in as well, okay? So take it away. Anybody on the panel?
Let me just take up the second question about fluffy agreements. I don't believe in fluffy agreements. I believe that whenever there's a settlement agreement, parties have committed themselves to perform. And if you go by statistics, there are very few cases in which parties have actually ended up in court, like his case, to enforce a mediated settlement agreement. So to encourage parties who are new to mediation, even though it may sound fluffy, because they put their heart and soul in the mediation and achieve a solution, in 95% of them, they actually carry it out. To the surprise of lawyers. Lawyers don't like cooperation agreements and say, we'll do your best endeavors. But I tell you, to the business people, when they sign such agreement, good faith is not like a bad faith. Lawyers must learn, okay? In the Asian context, good faith is not like a bad faith. Good faith means it's a positive obligation to do something good. Not, I didn't do anything bad, so it's not good. Okay, so that's my take on, I don't look down on agreements when they say they want to cooperate. I think if they really believe in that, they sign on it, they will bring to fruition.
Prof, if I could just jump in. It's interesting you raised that question. Actually, clauses like duty to cooperate, duty to negotiate in good faith, to take reasonable endeavors and so on. Actually, there is ample case law out of the courts which actually say that these kind of clauses can actually be given effect. They are recognized as being enforceable. I think we appreciate that. I think the point you're making is that it's not precise. It doesn't say, for instance, what precise steps need to be taken and so on.
My question was, yes, I do acknowledge that the courts can do recognize such obligations. My question is,
if you do need to accelerate the performance, I mean, I'm just comparing against a liquidated sum that you agree, and you also agree to have an acceleration clause to get summary judgment if one party doesn't perform. But for a cooperation kind of obligation, I don't think we can have any acceleration there. I mean, parties can't get along, just have to come back again and knock our heads together and find another resolution. So that potentially just postpones the dispute to another time. I mean, that's my thinking.
So ideally, you want to have all these issues ventilated and considered before you put pen down to paper.
I think that's what we want to add to what Josephine was just saying, clarity. By the time you get into a settlement agreement, your mediator would have reality checked all your terms of agreement that it's feasible. I mean, you cannot go and put things in what if it's what if and it's not impossible, he will probably nudge you in the right direction. I think that's, for those of us who believe in the cause, that's, when you settle, it's going to be something that works.
What I must say is that in all the mediations I've done, we always get the lawyers to draft, at least I always get the lawyers to draft the agreement. And actually that's a very difficult part. We can have, very often my mediation ends at 9 o'clock at night. And they will start drafting, and 2 lawyers drafting an agreement is bad. With 4 lawyers drafting and 8 pairs of eyes on the same document is going to be worse. So, but I don't care. I think it's better that we suffer at those hours, get the lawyers to work on it, quarrel about it, it's okay, and then finally get it signed. Yeah? And it's unlike the committee mediation where the mediator writes it. Here we have lawyers writing it, and they will quarrel about it, fine. They'll be talking about this was and has and should or shall, would do or should do or must do, We'll quarrel about that, but in the event, in the end, they will come up with a document. And then when sign off, they will comply.
I know that there are certain views that you want to put forward, so let's just set ourselves the timing, because I recognize that it's coming to Friday evening, and some of you may think, hey, hurry up, finish, I'm going to go and eat makan or what. So can we just have maybe 5 minutes? Yeah, there are some other questions, but we'll just take 5 minutes, and then the rest of you want to stay on and continue to ask the panel, feel free. Okay, so there are a few other questions. Let's ask.
Lawrence, with you on the lawyers drafting on the spot, regardless of the time, I just want to know your thoughts about this type of scenario. Do you actually get involved in drafting at all?
Sometimes to break the deadlock.
To break deadlock?
Yeah, to break deadlock among lawyers.
Right.
So lawyers will be quarreling, then I'll be standing behind the computer and say, why are you quarreling about this? Why can't we agree on this? We'll have a look at each other and then why not? So sometimes you intervene just to break the deadlock.
Okay. I want to know your thoughts about this. And this is a scenario that I had. After 10 hours of mediation on Palm Sunday, we were at the point of drafting the agreement. Two very tired lawyers.
You need doctors there.
Yeah, well, actually you're right. But 2 very tired lawyers, not drafting very well. And at some point, I felt some duty to get involved and put them in front of me and say, now just explain what you want and we'll get it done. Interestingly, the parties signed, and as I think someone pointed out, what happens when they go back and the third party start asking them? In that particular case, it involved the withdrawal of a suit, and the judge actually wanted to meet the parties to get them to confirm they had agreed to the settlement agreement. This is just to share an experience. What had happened was one of the parties actually wanted to back out. And it was the lawyer, so that was the lawyer in the picture, who later shared with us that she asked her client, what has changed? And she ended up having to do outside coaching, counseling, whatever it is, because there were third-party influences. And I think that's sometimes that's the post-mediation assistance a mediator can give to mediation advocates, because that is a risk. Yeah.
It is. Sure. So I agree. I think sometimes you just got to step in to help draft if necessary. Yeah. Sometimes I do that.
Yeah. Lawrence, can you just finish up the other
last question is whether if there's fraud, crime, or fraudulent intention being disclosed in the course of mediation. This is a very sensitive one. I think we as mediators have ethical duties as well. I take the position that if there's crime involved, or I know that one party is not prepared to do anything, he can sign anything but he's not going to perform it, I'll walk out of the mediation, I'll terminate the mediation without having to tell the other party why, that this is a crook or what. I think we are not going anywhere, and that's terminated. And I think it's better for both sides. Yeah. Well, in terms of crime, I think we do have, if it's a seasonal offense, we do have some duties, even as arbitrators. Yeah? Confidentiality, without prejudice, whatever notwithstanding, there is a law in Singapore that obliges us to report certain crimes. So too bad, those who still think that you can get away by under confidentiality, that you can commit anything you like, it doesn't work here.
But when it comes to other things, I mean, it's a very large divide. Yeah? There's a gap there. There's a big, thick line there. It can be crimes, or it can be secret information that I just don't want the other party to disclose. And I just want to make sure that we're clear on this, that the duty to keep things confidential is really sacrosanct in a mediation. It has to be. You're the mediator. Parties have to trust you. You're completely neutral. And if they tell you this is just something really embarrassing, I don't want you to disclose this, you don't disclose this. You just don't do it. I've had a mediation where the daughter tells me in a private session that her mother is dying of cancer and her mother doesn't know. And I had to be very, very careful to make sure that that the poor old lady doesn't know. And I have to confess, I kept looking at her and thinking, oh my God, you only have 2 months left. This is terrible. This is terrible. And so the duty to confidentiality is sacrosanct, just to answer your question. Okay? Was that all 4 questions covered?
Yes, I think so.
Now, I realized there was one more. What was that?
The legal opinion.
Legal advice.
Oh, you missed that one. Okay.
Never
Sorry, I was
give
in the
legal
restroom.
advice. I never. No.
No, yes.
You not even use that as a tool to sort of come to a
Well, I would do that during relative testing, especially if there are lawyers around. I'll ask the lawyers, but not advise the clients. I say, have you thought of this, and where do you think we stand? Do you think this will stand up to? You know, so I'll test with the lawyers, just spar with him mentally, you know. But nothing more than, I wouldn't tell the clients, if you're a lousy lawyer, you're giving me wrong advice. Never.
No, I mean, when you're a mediator and you're wearing that hat, it doesn't matter whether you were a judge, or you were a lawyer, you were a carpenter, you were a plumber. You are now a mediator, and so you should stick with that hat. And the worst thing you could do is to have both parties in front of you and say, if I were the judge, you would. Because why? Because why? Because the whole point of mediation is to create movement in the parties. You move from your position. And if you tell him that your case is really weak, or his case is really weak, do you think that you will move from your position after that? No, you won't. And then that mediation will fail.
It cannot happen in a joint session. Maybe it can happen on a private session.
Oh, in a private session, what would you do?
Yeah, I'll do the same. I don't think I will give advice, but to the lawyers, I'll tell them, hey, really seriously think you have a good case? I'll sometimes cast doubts and say, why do you think you have a good case? Have you heard of this? I'll discuss with him, Amolat, but never say that he's giving.
I think it's also, the benchmark is really impartiality. And also from a very practical angle, if you have a mediator in private caucus, even private caucus, who's questioning the lawyer too robustly, can assure you that lawyer will never ever pick that mediator ever again.
Also, as a mediator, I don't know the full facts.
Yeah.
I won't have the instructions the lawyer has. So I can't claim to be able to give legal advice at all.
And lastly, here's a reminder, not all mediators are lawyers. Not all of them were ex-judges. Okay? Now, I think we have had really great questions. I'm going to ask you a question. Amolat,
Okay, go out like real quick.
In 30 seconds.
Okay.
I also do some mediation at the state courts and in the family court. What you say is very true, because sometimes we reach a stage, even more so in family cases, the party cries and says, okay, Mr. Singh, you tell me what I should do. So I just want to reinforce that. You never go there. I always tell them,
Don't go
look,
there.
this is your decision. I'm just managing the process. Thank you.
So my question now to all of you, since you've spent the whole evening asking us questions, is, did you enjoy this session?
Yes.
Did you find it useful? Will you please sign and write and fill in the feedback form? Hey, yes? No? Yes. Before I release you, just remember, we are always trying to make things better for you. This is the spirit that we carry with us. And so, for us to learn better, I think you give us honest feedback, as thoughtful as possible, and then maybe you can go have your tea. Alright? And please remember, if you continue to have any more questions, or you want to speak with any one of us, you know, from 5:30 to 6 o'clock, we're still on duty. You can still ask us questions. I know Clara's got so many burning questions, Clara.
Just one.
Okay.
Sorry, I think this is important. I don't think it's just I who have that question. From what Eunice shared about the new law that's being considered, I find it a bit hard to really bridge that gap because you emphasize so much about confidentiality. So met up, I can understand because it can be kept confidential, right? But how do you convert a mediation decision into a consensual judgment and still retain the confidentiality? I mean, sorry, my mind is just a bit kind of wound down.
That was what was running through my mind.
Okay, so that you've got multiple people want to know about confidentiality.
Because whoever is coming in, you are talking about mediation. In the end, ultimately, it's enforceability. Then it all comes back to whether you do it through a easier version mediation, then you go arbitration, not happy, you go litigation. In the end, you still turn it into enforceability.
Oh, you go all the way to litigation after you fail mediation? Oh, no, madam. Eunice, can you please come up here?
Is this a way to simplify the lawyer's job?
Can I have Singh come up here as well? Singh, I think we need reinforcement.
This question, is this a way to simplify having less cases at litigation levels? Because then you are turning it into enforceability subsequently.
Okay, let me just address the point about confidentiality first. So really it is a question of parties' choice whether or not at the end of the mediation they want to, under the new law when it comes out, actually obtain an order of court to support that mediation agreement. If you want confidentiality, then of course you cannot do that. A court order will be public. In relation to the next question, I think there's some, the question was really about whether or not mediation is just part of a process where you try something first, and if it doesn't work, you go to arbitration, and if that doesn't work, you go to litigation. Okay, so I'll just give my view first, and Selvaraj will jump in. So mediation is something that can be used at any time. So it is possible to use mediation as the first port of call when a dispute arises. So you try an amicable way of resolving before you go to the next stage. The next stage could be arbitration. The next stage could also be litigation. But as I think Prof. Bu mentioned just now, and I think it's also important to highlight, really the vast majority of mediated settlement agreements do not go that far. Mediated settlement agreements are generally voluntarily enforced.
It stops there.
Yeah, and here comes the hard sell. You know about the product now, and I'm not going to make any excuses. Why mediation? Okay, just to nail this down, in case it hasn't already been done so. First of all, you want to try it because you have control over the outcome. If you go to arbitration or litigation, there is always the risk of an adverse outcome. There is very little to lose in spending one day with the mediator. If it's settled, great. If it doesn't, you still have your other options. It's much cheaper, much faster. You preserve relationships. Who comes up with the solution? The parties come up with the solution. That also gives you the power to come up with practical, pragmatic solutions. If you go to court, all you may get is a paper judgment. And for instance, if you get a paper judgment against a person who has no money, it's of completely no value. Okay, that's your answer.
Just one more thing to add on to what Singh and Eunice said. Even after you start arbitration, you can mediate. Even after you start litigation, you can mediate. I mean, that's something to think about.
I think the starting point for us in terms of enforceability is, as Lawrence Wu has said, because it is a voluntarily entered into solution, cases of default in our 18 years has been very, very, very rare. But if you're really concerned about it, there are ways of making it enforceable, to let it have more teeth. First level, it is already a binding contract. Second level, if it is a matter in court, consent, judgment. If it's a matter in arbitration, consent, arbitral award. So there are ways. But remember, most importantly, chances of default are generally very rare.
Yeah, and on that note, before we go to tea, can we just give a round of applause to our moderators and our Thank you very much.
All right, it has been a real pleasure. That, come up here. It's been a real pleasure just hosting you. We love talking to people about mediation. So if you have any questions at all, feel free to come up and talk to us. We are all very friendly here, as you can see, some of us more so than others. And we would like to invite all of you for this wonderful tea on Sing On outside. And we'll be hanging around here and hanging around us if you have any questions. Thank you and have a wonderful weekend.
Thank you.
Yeah.